Up to order. It's 9:01, and I'd like to, Wesley Davis will give us the invocation, and if you'll remain standing, please, Commissioner O'Brien will lead us in the pledge.
Our Heavenly Father, we thank you for the opportunity we have to come before you today and conduct the public's business and gather some information on the future of our community. In your name we pray. Amen.
Amen. Please join me. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
And we're going to have a presentation on charter government. This will be a workshop, and as I introduce Mr. Kurt Spitzer, he is going to do a PowerPoint, and then we'll go through and get a briefing on the draft charter. And after that's finished, we'll go into questions from the Commission, and then we'll open this to the public for your input and thoughts on what you've heard at this meeting and what your interests are as far as the charter goes. So, Mr. Spitzer?
Thank you, Mr. Chairman. Commissioners, I thought that what I would do today is to go through a brief PowerPoint discussion. This will be somewhat similar to that which we had a few weeks ago. Many of the people in the audience today were not at the meeting, at the last meeting. And then we have a discussion draft charter. And that document is laid out in landscape fashion. The language of the charter is on the left side. Any comments or observations in terms of options for doing something different that you might want to consider is on the right side. And in terms of the first draft of the language, I have tried to mirror practices as they currently exist in Indian River County government. Have not tried to make any changes there. Now, there are some areas where, because you're a non-charter county, things are not applicable at the present time. Ordinances by initiative, Charter Review Commission, those sorts of things. So those are new, but they are certainly subject to revision, changes, amendment, deletion, pursuant to direction that the County Commission wants to give me. Just a couple of brief slides, since we're really sort of starting out here yet again. Important to understand the difference between Dillon's rule and home rule. Dillon's rule, which is what local governments operated under prior to 1968, the constitutional revisions in 1968, says that a local government has only those powers which are specifically granted to it by the state, either in general law, special law, or the Constitution. Home rule is the opposite. Home rule says a local government has all powers of self-government except those that are specifically prohibited or preempted by the state. And so under the Dillon's rule system, the county attorneys, city attorneys look for specific authorization before their legislative body can take action. Under home rule, you do the opposite. You look for a prohibition. So it's a very different system of policy setting at the state level. As I mentioned, this all changed in 1968. For county governments, non-charter counties in the Constitution were granted all powers of self-government as provided in law. And the Florida legislature in 1971, 1972 passed significant changes to Chapter 125 Florida statutes, which is the county government chapter of the statutes, authorizing broad home rule powers for non-charter counties. For charter counties, home rule is really self-executing. It's broader powers and includes the powers to change structure, change relationship with other jurisdictions within the county government, and that is specifically authorized for the voters of a county in a charter county. So, 19 out of the 67 counties in Florida have adopted charters. Sort of used to be that was reserved exclusively, or the practice was observed, I should say, exclusively in the really large urban jurisdictions. You can see, though, that that no longer is necessarily the case. Charlotte, Clay, Columbia counties all have adopted charters. Charlotte was about 80,000 people when their charter was adopted. Clay was about 90. Columbia was 55,000 or so when they adopted the charter in 2002. About 80% of the residents in the state of Florida live in a charter county. So in terms of general provisions, let me just quickly go through these. First of all, I think it's always important to remember that the charter is not adopted by the county government, by the county commission. It's not adopted by the legislative delegation. It's not amended by the delegation, by the county commission, by the county manager. It's only adopted, amended, or repealed by the electorate, by the voters, in this case of Indian River County. Typical policy areas that are addressed in county charters include the legislative branch and the relationship between the legislative branch to the administrative or the executive branch of government, the county constitutional officers, city-county relations, and then there's typically sections that are entitled Powers Reserved to the People, which concerns the initiative process. In terms of the county commission, the default system in Florida is a system of 5 county commissioners residing in 5 different residence areas, but elected by all of the voters on a countywide basis. That can be changed in the charter. The size of the county commission, 7 or some other number, the terms of office, districting schemes, at-large, single-member districts, some combination of both, all can be addressed in the charter. The constitutional officers, 5 independently elected constitutional officers, which really are entities of the state government that happen to be selected by the voters within Indian River County, that can be changed by the charter. And most charters don't address that. Some do. Of the ones that are affected, of the offices that are affected by the charter, they need not be affected in a uniform manner across all of the 5 different officers. You can treat some offices differently than others depending upon what the voters of the community approve. Non-charter counties, as we've just said, have all powers of home rule as provided by general or special law, and this is important for today's discussion. An ordinance, a county ordinance that conflicts with that of a city is not effective within the city limits to the extent of the conflict. For charter government, it's a little bit different. Charter governments are directly granted home rule powers by the Florida Constitution, and the charter is required to state which ordinance prevails in the event of a conflict between a county and a city. Now, to meet that test, most charters, about half the charters in Florida, simply state that in the event of a conflict, the city ordinance will prevail. About half identify at least 1 or 2, maybe more, policy areas where the county ordinances are authorized to be applied countywide, and where the cities are always empowered to have more stringent ordinances, but not less stringent ordinances. And we'll talk about this as we go through this morning's presentation. I think it's important to, again, remember that the initial adoption of the charter and any amendments to the charter are only approved and made effective by a vote of the electorate in Indian River County. So in terms of home rule, both constitutional and as put into effect by statutes, both non-charter counties and city governments have pretty broad powers of home rule in Florida, different than many other states. In many other states, city governments, county governments are really envious of the powers that county and city governments have in the state of Florida. The difference, though, with in a charter county is that the citizens are authorized to determine which government is empowered to set standards on a county-wide basis. So in terms of options for sending a proposed charter to the voters, there's really about three. Special act. It's a special act adopted by the legislature. It's promoted by the delegation, but in fact the entire legislature of the state of Florida would have to adopt this. You could create a charter study commission. Most charters, although certainly not all, but most, the initial charter has been presented to the voters as the result of a charter study commission. This is created by resolution of the board. There's statutory guidelines in terms of how many people serve, that sort of thing, and they are granted up to 18 months to present their work. So, for example, if you were to create a charter study commission now, their work would be on the November 2008 ballot. They, by the way, must propose a charter. The option of not proposing a charter does not exist for a charter study commission. They must propose a charter. They are independent of the county commission. Their recommendations will come back to the county commission, but only for the purposes of procedurally placing it on the ballot with the supervisor elections. You are not empowered to reject or amend any of the recommendations of a charter study commission. And the third method by which a charter may be presented to the voters is by ordinance of the county commission. That's specifically authorized in Chapter 125 Florida statutes. So are there any, do you have to take any questions concerning these sort of procedural background issues at the present time?
Any commissioners, any questions at all so far? Yeah. Oh.
You have in front of you a discussion draft of a basic charter for the electorate in Indian River County. And as I said before, I have tried to pattern the policies in this draft charter so that they follow practices of Indian River County government. The first article is really technical and procedural in nature, creating the Indian River County government as a charter county. It has directive language that says that the powers granted by this home rule charter shall be broadly construed in favor of the charter government, recognizes that the county government has all home rule powers that are not inconsistent with this charter or with the Constitution or the statutes in Florida, recognizes that the county government has certain powers for municipal purposes, which you really already do in the unincorporated area. This 1.4.2 tracks current law. 1.5 in terms of transfer of powers, if the transfer is done on a voluntary basis, this recognizes that you may accept these transfers of responsibilities on a voluntary basis, and clarifies that such transfers are not intended to be in violation of Article 8, subsection 4 of the Constitution, which requires, if it's done on a permanent basis, a dual vote. Maybe I should stop here and talk about the so-called dual vote for just a minute. We talked about this at your last meeting. Amendments to the charter which set standards or authorize regulatory power on a county-wide basis under the Florida Constitution need only be approved by a single county-wide vote of the electorate of Indian River County. Amendments to the charter that seek to transfer the responsibility for programs, or I should say people or assets, a police department, a fire department, things that move the assets of one jurisdiction to another jurisdiction, must be approved by a dual vote. And the dual vote occurs, the vote occurs during a single election, but it's counted in two different ways. One, the amendment proposing the transfer must be approved, of course, by all of the voters on a countywide basis. Secondly, though, the amendment approving the transfer must also be approved by the voters within the municipality from which that program or asset is to be transferred. Okay, so that's the nature of the dual vote. The Constitution requires that when you're moving people or assets, there must be a dual vote. This clarifies that if this is done just on a voluntary basis, that should not be construed to violate that section of the Constitution. Moving on, there's a division of powers between the legislative and the administrative functions of county government, just as you have at the present time. And in 1.8, I know there's a lot of folks from city governments here today. The language within the charter provides that city ordinances prevail inside a city limit to the extent of a conflict with that of a county ordinance. That is certainly an area that you, as a policy decision, you are free to suggest what programmatic areas, what policy areas you think should be able to be applied to all of the residents of Indian River County on a county-wide basis. It is common. I can't say off the top of my head if it's a practice in a majority of the county charters, but it is common that matters such as environmental protection or planning, there is an identification that the county government is empowered to adopt ordinances that apply on a county-wide basis, and we can talk about this further when we get further on down in going through the charter. So that's Article 1, which is really a sort of a general introductory article to the charter. We now move into Article 2, which concerns the legislative branch. Again, the charter establishes a commissioner-administrator form of government. The commission is responsible, as you are today, for setting legislative policy. The administrator or manager is responsible for implementing that policy, and it establishes a separation of powers between the two branches of the county government. There are 5 members of the county commission residing in residence districts but elected on an at-large basis in partisan elections. And the commissioners must reside in the district during the term of office. They need not reside in the district when qualifying as a candidate. This is right out of general law and your practice in Indian River County. So in terms of options, there are many options, and you could have some other system in terms of the number of county commissioners. There could be 7. You could have commissioners elected from single-member districts or some combination of single-member districts and at large. In a couple of counties where they have gone to 7 county commissioners, it's a mixed system where 3 of the commissioners are elected on an at-large basis, 4 are elected from single-member districts. Each elector then has the ability to vote for a majority of the county commission districts. And there are all sorts of policy questions surrounding the question of single-member districts versus an at-large system. The charter may provide that the commissioners are elected on a nonpartisan basis. Several do. Most have retained the partisan election system. The charter may provide that the candidates for office must live in the district at the time that they are qualifying to run for office, and several charters make that requirement. It's an option that you could consider. The charter tracks general law and your administrative code in that the county commission must redistrict at least every 10 years after the census is done by the federal government. You may redistrict sooner, and you're currently authorized to do that at the present time. If you do that, that must be done, made effective in an odd-numbered year. The charter could provide some guidance to be followed in the redistricting process, such as attempting to follow significant man-made or natural boundaries, significant roadways, water bodies when drawing districts. The charter could provide that in the redistricting process you attempt to not split city governments into 2 or more different district boundaries. Could provide that as a policy guidance in the future. The charter provides that compensation of the county commission is as provided for in non-charter counties by state law. This is a population-driven statewide statute that all non-charter counties follow. Most charter counties, the overwhelming majority of most charter counties, follow also, both for the commissioners and for the elected constitutional officers. There could be a different system put in place. You could identify a compensation amount in the charter. You could provide that compensation is as provided by ordinance of the county commission, those sorts of things. In a charter county, the legislative body, the Board of County Commissioners, must be subject to recall. That's not an option to not have. You will be subject to recall, and it must be as is provided in state law. There are no options in terms of not having recall policy. There are no options in terms of changing the things for which someone may be subject to a recall petition. And it's a tough process to go through, as it should be. It's a 2-step process where you first get a certain number of signatures. If those are verified, then the person who is being recalled from office has an opportunity to respond to the allegations in the recall petition. Those 2 documents are merged together, and then a second signature process is initiated, which I believe requires 15% of the voters to sign the petition, and then it's presented to the voters for an election. That can't be changed. That's frankly is rarely used in Florida law. That might be applied, I might say, to the constitutional officers as a policy decision that could be added to the charter, and I think it could be done without affecting their independent constitutional status. In terms of meetings and Article Section 2.7, I believe, if I read your administrative code correctly, your organizational meeting is held in January. It's not.
We changed that to November.
Okay. Well, we could change that, or you could make it some other date, but this would be the first meeting in November after the
Election.
After the election, okay. All right. At that meeting, you select a chair and vice chair for the coming year. Again, special meetings, I hope I've captured the practice in the administrative code correctly. They can be at the call of the chairman or the vice chair, or at the request of a majority of the county commissioners. Requires at least 12 hours notice. I think that's consistent with the administrative code. You could have other policies. You could require just that 2 commissioners call for a special meeting. You could require that actions taken at a special meeting are limited to those matters for which the special meeting was called, as a matter of policy.
Yeah, the only difference is I don't think ours provides that not less than 12 hours, or does it? Well, ours simply says may.
I believe your code says 12 hours.
Yeah, you don't always follow it.
No, I don't think that's what it says.
Well, it says whenever practicable, so how do you interpret that?
Yes.
Okay.
Okay.
It does for 12 hours.
All right. Locations of the meetings are in the county seat, and then the powers of the county commission are identified in several different subsections of Article 2. Or Section 2.8. First of all, to appoint and reappoint the county administrator by a majority vote of the entire county commission. That means at least three votes. And to remove the county administrator during a contract term by a majority vote of the entire board at each of 2 successive regular meetings. You could do otherwise. You could provide that the administrator may be terminated by a majority vote at 1 meeting, or in some charters you see where there is an attempt to make it more difficult to terminate the administrator, requiring that a majority plus 1 vote would be necessary at 1 meeting, or perhaps a majority vote at 2 consecutive regular meetings of the Board of County Commissioners. In terms of subsection 2 of 2.8, County Commission is empowered to adopt ordinances as may be necessary to carry out both county and municipal powers and purposes. I should mention that because of a court case many years ago, which was reaffirmed a few years ago in the Supreme Court of Florida, charter counties are empowered to impose the so-called municipal utility tax in the unincorporated area. This operates in a manner that is very similar to your franchise fees that you have, I believe, at the present time. It is a little bit broader, more liberal benefit test, but it would be limited to services that you provide in the unincorporated area. You could put a prohibition against this in the charter, or you could require that it must be approved by some extraordinary vote of the county commission. Of the 19 charters that currently exist in Florida, only one has an out-and-out bar against the utility tax. All of the rest are silent on this subject, and about half of those the county commission has imposed the utility tax in the unincorporated area. The other subsections of this section are pretty straightforward and mostly taken out of your administrative code. I will bring special note to subsection 4 on page 8, which requires an extraordinary vote to adopt rules of parliamentary procedures.
Wonder what?
Something different.
Page 8, subsection 4, majority plus one vote. The alternative, obviously, is to just require a simple majority vote. And in 2.9, all actions of the county commission are taken by a majority vote of the entire board. So at least 3 affirmative votes to take action. And there is a requirement that you adopt a code of ordinances. So that, I believe, is the legislative branch. Mr. Chairman, I'd be happy to answer any questions if there are at the present time.
What's the wish? Do you want to go through all of this and then go back to questions, or do you want to take it article by article, subsection?
Just keep going.
Keep going. That's fine with me,
Okay.
too. I think it's the best way.
So then we move into
We may never get to the end if we do it the other way.
we move to the executive branch, the county administrator. Again, this draft establishes the commission administrator form of government. The Board of County Commissioners employs a professional manager who is retained based on training and experience, who is responsible for implementing policy established by the Board of County Commissioners. Much of this language in Article 3 generally tracks Chapter 125, which authorizes non-charter counties to adopt a county administrator form of government, or similar provisions of your administrative code. And again, the administrator is hired by an affirmative vote of at least 3 commissioners, and the current draft is terminated by a similar vote that occurs during 2 consecutive regular meetings of the Board of County Commissioners. Subsections 3.3(1) through 12 through 13 really are standard provisions, either from Chapter 125 or from your current practices in the administrative code. Now, if we have missed something or misinterpreted something, please let us know. The intent here was really just to reflect current practices in Indian River County concerning both the legislative body and the executive branch. Now, there is in 3.4 a non-interference clause which prohibits members of the board from interfering with the performance of subordinates to the county administrator by giving instructions or directives. In many non-interference clauses, you will see where, except for the purposes of inquiry and information, members of the board are prohibited from interfering with the duties of an employee of county government who's under the direct or indirect supervision of the county administrator. We went through a charter review process recently, and the question came up, well, what does that mean? I mean, what does interference really mean? And so we added this phrase at the end of that sentence that attempts to clarify that giving employees of the manager instructions or directives, that's really what non-interference clauses attempt to address, and so that's what we have reflected here. That's not in your administrative code, but I think it's a clarifying phrase. Such actions, though, is malfeasance, which is grounds for both suspension from office or a recall petition under a charter government. Of course, asking questions, referring citizen complaints, those sorts of normal actions do not constitute interference. But the chronic, frequent, ongoing giving of instructions or directives to a subordinate of the administrator would constitute interference. All charters have language which is similar to this, with the exception of this phrase on instructions or directives, but pretty much all charters have a non-interference clause. So, page 14 is a computer error. You've seen those documents where sometimes they say this page intentionally left blank. Well, this page has been unintentionally left blank. It's just a formatting problem. So we move on to Article 4 on page 15. Unless there are any questions about the county administrator article. All right. 3 subsections here. One is that the initial departments after the charter is adopted are those that exist upon the adoption of the charter. Department heads are appointed and terminated by the administrator. It is not uncommon to see charters where the appointment of department heads are subject to confirmation by the Board of County Commissioners, or you could require that, provide that the administrator has the power to employ department heads, but after consultation with the members of the Board of County Commissioners. The county attorney is the county administrator's position, by the way, is what's called a charter officer's position. It's one of, in the present draft, a specifically identified positions that are required to be filled by the Board of County Commissioners. The county attorney is also a charter officer. It clarifies here in subsection 4.3 that the attorney is appointed and terminated by the Board of County Commissioners, is the head of the Department of Legal Services, and provides services to the board, county department, and county departments and other county boards and agencies. This article does not make a reference to your executive aid, which is identified in your administrative code. You could add a reference to the executive aid or executive aides being retained or employed by the Board of County Commissioners if you so chose. Article 5, the county officers, 5.1 is standard language concerning the 5 constitutional officers, provides that they remain as elected county constitutional officers. Their powers, duties, functions are not altered by the charter. The selection process for the county constitutional officers is not altered by the charter. There are numerous alternatives to this system that you could consider if you wanted to. Article 6, powers reserved to the people, primarily concerns a process by which the public may propose ordinances by a petition process. In the current draft, it requires the signatures of registered voters equal to at least 8% of the electorate who is qualified to vote in the last general election, and that 8% must be obtained countywide and also in at least 3 of the 5 commission residence areas. The latter criteria is important so that one particular area of the county could not obtain all of the signatures required to get 8% countywide and therefore drive what gets to the ballot. And this is true both in the ordinance process and also in the charter amendment process, which we'll discuss in a few minutes. Basically, this process, once the required numbers of signatures are obtained, the sponsor presents the initiative to the supervisor of elections. The sponsor of the initiative presents the measure to the supervisor of elections. Then a 180-day clock starts to tick, and the proposer of the initiative has 180 days to obtain the required number of signatures. It could be longer than 180 days. That's a policy question that you may wish to consider. And by the way, the charter does not have to have a provision by which ordinances are, there is the ability to prepare ordinances by petition. Most charters do, but not all. And you know, it's a policy question. You don't have to do that. Once the required numbers of signatures have been verified, the county commission holds a hearing on the ordinance. If the commission does not adopt the ordinance, there is a requirement that the ordinance must be placed on the next general election ballot. If the ordinance is approved at that time, it may not be amended or repealed by the county commission in this language until the next succeeding general election, after the voters have an opportunity to vote at the next general election. Then that commission would have the power to amend or repeal the ordinance that has been adopted by this process. I can tell you that even though many charters have this option in it, it has been very, very, very rarely used. In fact, I believe, to my knowledge, it's been used just once in one particular county in Florida. There are alternatives in terms of the number of signatures, in terms of the length of time that the proposer has to obtain the correct number of signatures, and also you need not retain the provision that there is a bar against amending the ordinances for a certain period of time. You could allow a different kind of a stopgap measure where by extraordinary vote of the county commission you may amend or repeal the ordinance that has been approved in this manner. There is a limitation on subject matter. These types of limitations, both for ordinances and for charter amendments proposed by petition, are common, and in 6.1.3 it basically attempts to ensure that the subject matter of such ordinances is limited to matters that are consistent with the Constitution, general laws, and the charter. As the county attorney knows, there have been court cases that have found that matters relating to budget and tax rates are reserved to the county legislative body, to the Board of County Commissioners, for their discussion and debate. In its current form, matters relating to the salaries of county officers, since the charter provides that salaries are set by state law, an ordinance doing otherwise would be inconsistent with the charter. So that's the intent of this language here. And again, members of the Board of County Commissioners are subject to recall as provided in general law. You cannot waive that or change that policy. You could provide that recall is applicable to the county constitutional officers. Moving on to Article 7. Most of the first several subsections of this article deal with the transition from a non-charter to a charter county government. In fact, subsections 7.1 through 7.2.6 all deal with the transition from a non-charter to a charter government. In terms of substance, the last few subsections, 7.3 and subsection 7.4, are policy matters. In terms of charter amendments, in addition to the legislative delegation always being able to present an amendment to the charter to the voters of Indian River County, there are three ways that amendments to the charter can be placed in front of the voters of Indian River County. One is by a proposal from the Board of County Commissioners, and this draft requires a majority plus one vote to present the amendment to the voters for their consideration. Secondly, by petition of the electorate. This is a process that is similar to that which we have discussed concerning ordinances by petition. In both cases, there are limitations. There's a single subject rule that's applied, and that means that the subject matter of the ordinance or the charter amendment can only cover one subject. In terms of charter amendments, since the charter operates as the Constitution for the voters of Indian River County, there is a more stringent threshold to obtain in terms of signatures, and in this case the draft requires signatures equal to at least 12% of the electorate to put the question on the ballot. There is a similar list of prohibited subject matters for charter amendments, similar to that which exists for the ordinances by initiative. And then in both cases, the amendments are effective only after approved by a vote of the electorate. majority vote. You could provide otherwise. You could provide that instead of 50% plus 1, it could be 60% of the voters to approve an amendment to the charter. And finally, there's a required charter review commission. Of the 19 charters in Florida, 17 have a process that requires a regular citizen review of the charter. Of those 17, 15 of those citizen reviews are done by an independent review commission. And that means that the county commission appoints the members to the charter review commission, and there's various options that you could consider in terms of the number and types of people that can serve or can't serve. But once that body is appointed, its recommendations go right to the ballot. They don't come back through the Board of County Commissioners. That's how this is drafted here. Most charters, the overwhelming majority of most of charters in Florida, have independent charter review commissions, but you don't have to have that. You could have them. You don't have to have a charter review commission, or the charter review commission could be advisory to the Board of County Commissioners. That exists in 2 charters, where the recommendations of the charter review commission comes to the Board of County Commissioners. The county commissioner is empowered to amend or reject any of the amendments of the Charter Review Commission. There are several other policy questions embedded in this paragraph. As it's currently worded, the Charter Review Commission is appointed every 10 years. It doesn't have to be every 10 years. It could be every 6 years or every 8 years. The first CRC occurs 10 years from now. It's not uncommon to have the first CRC appointed at some shorter period of time, maybe 4 years, and then roll over to a longer interval between when the CRCs are appointed. This paragraph has a bar against elected officials and employees of state or local government from serving on the CRC. You don't have to have that bar, but the idea here is that this is the charter for the citizens of Indian River County, and that the reviewing body should be independent of existing governments within Indian River County. I might also say that in this subsection of this 7.4, this specifically authorizes the repeal of the charter. There are no other charters in Florida that authorize consideration of measures that would repeal the entire charter. And there have been Attorney General opinions that unless repeal is specifically authorized in the charter, there cannot be a measure that considered by the voters that would repeal the charter. So this specifically authorizes consideration of measures to repeal the charter. Requires at least 2 public hearings separated by at least 10 but not more than 20 days prior to any final recommendations are transmitted to the Board of County Commissioners. So that concludes that section, Mr. Chairman. There is a supplemental document, 2-page document that is appended to the basic draft, and this is really intended just to sort of float out a couple of alternatives concerning the county's comprehensive plan and the rural boundary and the rural area in Indian River County. The first 2 draft sections, number 1 and number 2, make it more difficult to adopt changes to the county comprehensive plan. Number 1 provides that there must be voter approval for any comprehensive plan amendment. Before that plan amendment is approved, there must be voter approval. There is an exemption, or I should say a prohibition in Florida statutes for amendments affecting 5 or fewer parcels from being subject to policy set by referendum, and so that's the nature of the second sentence of that paragraph. However, that is addressed in option number 2, where for amendments affecting 5 or fewer parcels, there is a unanimous vote or some other vote required of the Board of County Commissioners. In both of these instances, you need not require approval by referendum or approval by a majority plus 1 vote. These are simply options that you could consider when considering the charter.
I need to ask a question on that. When you define a parcel, are you defining it as a property owner, or are you defining it as tax bill? I mean, for example, you can get a tax bill on 640 acres of sectional land, probably even larger than that. So, I mean, how do you define parcel?
It's as is defined in general law, and I'm not familiar with. That's right out of 163.3167(12).
Well, could you help me with that? And if not now, I need to have the answer to that.
I think it would be any parcel of land that has an individual tax parcel ID number.
I mean, a quick loophole around that.
Point,
yeah,
because a taxpayer can request, if they own multiple parcels of land, that they be sent one tax bill with one.
You can do it all the time. You can have 11,000 acres under one parcel. Just figure I'd throw that out for thought.
Which is the specific advantage that a special act would have over a charter, in that this 5 or fewer parcel exception doesn't apply under a special act.
I wouldn't hold your breath on a special act. I mean, but
that's a good point, though. That since it's an action of the legislature, that it would not have to be consistent with that subsection of 163.3167.
Okay.
So then we move down to option number 3. These first 2 options, by the way, were patterned after some recently approved changes to the charter of the City of St. Pete Beach, and that has been upheld in appellate court. The third option is patterned after the recent changes to the Seminole County Charter, and that has been upheld in appellate court in Florida. And the rural boundary, the intent of sub 3 is to try to lock down the rural service area, the rural boundary and the rural area, as is defined at a specific time, and we would need to identify as to when that time would be. But the intent here is that after the effective date of the charter, the land use designations as contained in the Indian River Comp Plan shall control the density and intensity of development in rural lands, even after such areas are annexed by municipal governments. That's the nature of the amendment that was adopted by the voters in Seminole County, and that was upheld, has been upheld by an appellate court. And this would be an exception to subsection 1.8.1 of the charter, which provided that municipal ordinances prevail within city limits to the extent of a conflict with county ordinances, except, and then we would add, if you wanted to, this particular subsection to the charter. The Seminole County policy did not require an extraordinary vote of the county commission to make changes to the rural area boundary. You could add some extraordinary means to make those changes. Majority plus one vote, vote of the electorate, those sorts of things, if you wanted to do that. But there are just options here that I've presented for your consideration. This does not affect the planning and zoning powers of city governments, other than when areas are annexed into their boundaries that are currently within the rural area. And I'd be happy to answer any questions that you might have.
Yes.
Yeah, go ahead, Wes.
Just real quick. Can you have the comprehensive land plan change for one parcel, regardless of the size, be in conflict with the rural lands designation? And I'm assuming the answer to that is yes. And if you do, then what happens? And the nature goes back to the change of the designation of the rural lands part. How would that hinder a parcel that may have been granted a change in the comprehensive land use plan? Because it's pretty simple to do with a supermajority vote, and it was fewer than 5 parcels.
Are you comparing sub 1 with sub 3?
Yes. Yes.
Well,
and I'm wondering if those conflict, then what happens?
I don't think that if you married them together, and you don't have to do that. I mean, these are just different options that exist. But if you married them together, sub 1 requires a referendum of the electorate to change the comp plan, and you'd have, if you wanted to do sub 1 with sub 3, we'd have to make some changes in sub 3 so that those two different phrases.
Not if it's one parcel, or if it's a single parcel, it still needs to go to referendum?
Oh, no, well, I don't think it can go to referendum if it's
Okay.
a single parcel, and so that's another thing.
That's my point. A single parcel property, and of course I'm obviously looking past an acre of land on this, but a single parcel of real estate in the comprehensive land use plan changing with a supermajority, but yet that being designated as a rural lands designation, which is what we have here in number 3.
Yeah.
What
we'd have to tweak that language if you wanted to do both of those things, so that for less than 5 parcels, we'd have to make a special phrase this language in a special fashion, so that the county commission, by some vote, could make those types of changes.
That's what you've done in number 2, I think.
Yeah.
Oh, it is. That's right. But you'd have to, if you wanted to take parts of those and merge them into 3, we'd have to rework that language in 3.
Okay. Anything else, Will?
In Seminole, by the way, I mean the policy that was adopted in Seminole County was that the rural area boundary was specifically identified by both a map and a legal description, and after the effective date of that charter amendment, the county policy, as provided in the county growth management plan, prevailed. Even after that area was annexed, that's all it did. It did not require any sort of an unusual approval process to make changes, though, to that rural service area boundary, and it was just a simple majority vote of the county commission. You could do that here if you wanted to.
Anything else? Any questions? Commissioner O'Brien?
Do we want to go back to the beginning and kind of walk through, or just pick up wherever we have a comment?
I think comments or questions, and then when we get through up here, we'll see what input we get from the public.
Okay.
Weigh all of it as we go through the workshops.
A couple areas I just had a question on. One, going back to section 2.3, qualifications for election for county commissioners.
Right.
Currently, it doesn't require a candidate to live in that district at time of qualifying. If we were to change that, where the candidate has to live in the district at time of qualifying, would that apply to write-in candidates as well?
That's only in the city they write in.
Oh, you think?
I believe it would
Okay.
apply.
Okay. Next section.
On that, though, just, I know the write-in, that was something different last year, but I don't recall, no, I'm sorry, take that back. I was thinking nobody's ever qualified that didn't live in the district, but I think they have in the past. Yeah.
For state representative, though.
Did you? Okay.
Section 4.3, well, kind of was talking about the county administrator and county attorney or charter officers. If we don't specify the executive aide there, then any type of aide to the commissioners would just fall under the county administrator as a county employee, and
that
all those rules
issue has been brought to my attention, and I think we might want to add that as a specific power under the Board of County Commissioners, under the legislative branch, that you could employ your aides that way. I don't think I would. My recommendation would be to not identify an executive aide as being a charter officer, which is what this sort of does. But the intent is so that you can employ an executive aide or aides directly, and not through the county administrator, I think, and we can work that in.
But would not be a charter officer.
Would not.
Okay. Then under the sections that dealt with initiative and then voter-initiated amendments, we have here the petitions must come from 3 of 5 districts.
Yes. Well, to obtain the correct number of signatures, whether it's 8% or 12% or whatever the number is, in both processes you have to obtain that number countywide, but also in at least 3 of 5 districts.
Okay.
You can delete that, or you can make the 8% required in 5 districts.
Well, my thought is just to prevent, I can kind of see maybe the mainland and the beachside districts, and you could get 3 mainland side districts to say, hey, we don't want to do sand pumping or something, and affect the beachside. So my recommendation would be that we change that to 5 of 5 districts to make sure that there's that either whatever the percent is, 8 or 12, is broadly through all voting districts, not just 3 of the 5. So my opinion there would be for 5 of 5. And then on the when it goes to the vote, a majority of electors voting, I think in the state constitution we just changed that, require any amendment to have 60% of the vote, and would that be appropriate to have that same level of standard at this?
Well, there are no charters that do that yet, but you could do that, and you may wish to consider perhaps applying that to charter amendments, or maybe distinguishing charter amendments from ordinances adopted by a petition process. Charter amendments are amendments to the Indian River County Constitution, and there is an argument that those amendments should face a higher bar, both in terms of being placed in front of the voters and maybe being approved by the voters.
Okay, so we could add 60% there. I think that's all I have right now, Mr. Chairman. Thank you.
Mr. Fletcher?
Nothing at this time.
Mr. Baum? And I don't have any questions at this point. Sure, we'll have some more discussion after public input. We'll open this up, and this is a workshop, and if anybody would like to be heard on your points of view, your suggestions, recommendations, you're certainly welcome. How many people would, at this point, think they'd like to talk, make a comment? Okay, why don't we start over here with, we'll start here and go over and back. And we can come back, too, if something comes up and you want to be heard and you didn't raise your hand, feel free to raise your hand, and we'd like to get input from everybody. So if you come up first, Adrian.
Adrian Cow, 43rd Avenue. The question I have, I don't know if it really pertains because it's on the last page that we were looking at, page 26, where it was adopted in Seminole County. So it's really not a part of our the charter that has been proposed for us. But it's B, where it says the Board of County Commissioners may remove property from the rural area and amend the rural boundary. Does that rural boundary mean urban service? Is that one in the same, that language? Yeah. Okay. So it is saying that accordingly, by adopting an ordinance by a majority plus one,
or unanimous.
Right, or unanimous of its entire membership, that doesn't that kind of defeat the whole purpose of having it by the electorate,
Yeah, what these are possible suggestions, and I think at some point in time, and I'd like to see, I'd like to see 1 and 2 combined, and then adjust 3, so they do coordinate. But these are suggestions.
So that was not.
This is what we're going to be deciding here and at future workshops, which ones we're going to point to.
Okay.
Or
thank
adopt.
you.
Can I just ask a quick question? And I guess it's seeing Ms. Cuff, it just kind of brought it to my, I don't know, just thinking about the 43rd Avenue issue. And Gary, I think you said it best, that if you thought that if the 43rd Avenue widening project would have went to the voters, you think it would have passed as far as a referendum. Remember you saying that one? I do remember you saying that. But just,
you're younger than I am, so you probably have a better memory.
But the reason why I say that is, so if we have an issue like that comes up, and you've got a group of individuals that are opposed to a project, and they want to, and with the charter form of government, they want to, we have 8% of the people that, the way Commissioner O'Brien's talking about, 8% of the people in the 5 districts put it on the ballot, and then it goes to the public, and then they vote on it. Then we would have an ordinance in place that states we will 5-lane 43rd Avenue. Is that, I mean, that's just...
Well, I'm not sure about that. I mean, first of all, I don't know the nature of that project, but matters relating to your capital improvements programs are prohibited subjects of the ordinance by petition process. But so there's that question there for starters. But if it was otherwise a permitted subject of the petition process, there's a possibility that the ordinance gets presented, gets the right number of signatures, gets presented to the county commission. The county commission chooses not to adopt the ordinance. It gets put on the ballot. The voters, by some percentage, approve the measure. Then under the current draft, the county commission may not amend or repeal that ordinance until the next succeeding general election. 2 years.
And if I can comment on that, Wesley, from my perspective, I can tell you first, I'd like to see 12% in order to change the charter. I'd like to see a 60% electorate majority, or the 60% to pass it, not a simple majority. And the other thing is some of these things, maybe not that particular one because it's capital improvements, but there may be some questions that are neighborhood related rather than county related. Mm-hmm. And I think that first it's going to be unlikely that they're going to get enough support to get the signatures. Secondly, I don't know if they can win by 60%, and you can't guard against everything. But I certainly think there's things like this that would come up that would never get off the ground and fly. I mean, you know.
Well, and I appreciate that, but what you're confusing, or what I think you're confusing, is the difference between a charter and an ordinance.
Well,
or an amendment to the charter and an ordinance. And basically what I was talking about is just an ordinance. And what you're talking about with the 12% would be an amendment to the charter, the way it's written. And I know we can do whatever.
No, we can change that. And but I don't know that you could have an ordinance that just simply says and again, it's that the example is a capital improvement, which is not part of what you can put to the electorate.
Mr. Chairman, Kurt, can we, on the page 26 here, subsection 3, we put in the definition of the rural area, which would coincide with the urban service line. Could we kind of combine all that where sections 1 and 2 only apply to those lands outside the urban service area, or the rural area is defined, and therefore any areas that are currently within our urban service area would just fall under normal county ordinances and procedures. So, Commissioner Davis, your question about 43rd Avenue, since that's already within the urban service area, would not be impacted by sections 1 and 2, but would just be dealt with through the normal county commission process.
Well, no, and the reason why I say that is because, and Commissioner Wheeler just brought up the point that, you know, he doesn't think maybe that we could get the 8% or the 12% or something along that lines. I mean, whenever that debate was raging, you were talking about basically not able to have concurrency. And we're fixing to deal with that. And at the time, I don't think, as a commissioner, I didn't realize how significant the issue of not being concurrent with what a road meant. Now, I'm well versed and can teach the class at the community college, I feel. And so I do believe that the issue of concurrency on those roads could have energized a community. And that's kind of my point is, is the beach renourishment issue, is that considered a capital project? And if it is, and we have that, if the ordinances go to a 60% threshold, I don't know. These are just some questions and I didn't really think of that until I saw Ms. Cuff just then, and I was just wondering. I know how passionate she was on that subject, and just to kind of get a little bit of information on exactly where we're heading with this. And I don't know.
What section is that under, Kurt? Oh, here we go. I found it. 7.3.2. And the way it's, and of course the options are over here too. I mean, it can be anything, but the way it's written is, in fact, it takes county budget, debt obligation, capital improvement programs. They aren't a part of being left to the voters, to a referendum, according to this, if I'm reading it properly.
That's right. But you're in the charter amendment section, but
yes,
the prohibitions are identical to the ordinance by petition section.
And I think those are, some of the concerns that we have that we can address through this. I don't think that we should, open this to where we've got government by referendum every time somebody has a neighborhood problem. I think that's something that needs to be addressed locally. I'm kind of looking at this as an overall, the county, what's good for the entire county, and not necessarily a neighborhood.
Yeah, but but what I'm wondering is, can it get to the point where it is government countywide addressing a neighborhood issue? And that's really my concern.
And then to piggyback on that, the comment, once you have charter, you can never go back. It's basically what I heard you say.
But no, you can, because in this draft,
It's authorized the repeal of the charter. It has to be done by vote of the electorate.
Right, and it's never been done before.
right.
There's never been a charter developed that specifically had a repeal authorization embedded in it. This does have that authorization.
Yeah, I think 7.4 goes there, and I think 7.4 really kind of outlines everything. In the last sentence is what Mr. Spitzer has added. After adoption of the recommendations, the Charter Review Commission may remain in existence in general election for the purpose of conducting, supervising public elections and concerning the, is that it? That's
Public
not it.
education.
No, where is that?
That's not it.
On repeal, it's in the
Yeah, where would
middle part of that paragraph.
Anyway, I think that should be in here. If the electorate wants to repeal it, they should have the right to repeal it. And I think this 7.4 gives a lot more authority to, or lays it out, the authority as to what the public has and what authority the commission loses and the charter.
Mr. Chairman.
Yeah.
And this is probably a question for Bob Keating. Didn't we remove 43rd Avenue at one time from our capital improvements projects? So therefore, would
Yes, we
43rd
did.
Avenue be a capital improvement project to go to the voters?
Well, we did remove it in the Board of County Commissioners.
I remember what happens, but I'm asking, I guess, more of a technicality. Is that
legal question?
I mean, and I don't mean to get hung up on this, but this is something that I don't know, the more I think about it, the more of a Pandora's box that we're just on this issue, and maybe it's something that we can address as we move forward with the charter. But if it's not in our capital improvement projects because the county commission removed it, does that make it a capital project?
If you add it back in, it would be, yeah.
But if it was added in by ordinance, by charter, it wouldn't be.
We'll have to think about that.
Okay.
I kind of think we're in that area, and I think it's legitimate, but I also think it's splitting hairs. I don't see something like that happening logically. And by the same token, that situation changed 2 or 3 times by coming in front of the commission. It'd be much more difficult to change it 2 or 3 times going to the electorate. Okay. Any other questions, commissioners? Who next on this side would like to speak? Over here on the right? Anyone? Saw somebody's arm come up. Oh, Mr. Johnson, you're up next.
Bob Johnson, Carlwyn Subdivision. I'm wondering if some consideration should be given to changing the county fiscal year versus, the county fiscal year and the state fiscal year are different. And I was wondering if there would be benefits to having the county fiscal year the same as the state.
Mr. Baird, respond.
I think the state, the county fiscal year is addressed in Chapter 129, isn't it? And Chapter 200.
It's preempted.
6 is preempted, and it's required that we have the October 1st through September 30th fiscal year.
So that's not something we have the latitude to change. Okay. Anyone else in this section like to be heard? Mr. Vaughn?
Commissioners, and Mr. Spitzer, thank you very much for your very helpful presentation. There were two issues. One Wesley brought up, which has to do with the definition of parcel, and that's left hanging, and that would give me a great concern.
Would you give your name, please?
Oh, pardon me. Ital Verone, 280 Pepper Tree Drive. I live in Indian River Shores. The second is just what we spoke about moments ago, which has to do with the Charter Review Commission. And Mr. Spitzer, you mentioned that could be advisory.
Could be.
I would not think it should be. And it would be my hope that it wouldn't be. So there are 2 areas. One, there is a definition available because it references a paragraph, 163 something, something, something. So I suppose we can look that up. But if, in fact, Wesley is correct and it could be thousands of acres, and I could see that it would be, I would have great pause for that. Thank you.
Thank you, Mr. Rowe.
To be clear, as currently is drafted, the CRC is independent. Your option is to make it advisory, but it is drafted as an independent body.
Yeah, I think that adds a lot to the how solid this is as far as the flexibility of the commission. I think that once this is adopted by the voters, that these things should apply because it gives them the power.
That it should be independent.
It should be independent, okay. Yes. Yeah.
Thank you, Mr. Chairman. John Williams, 1535 Smuggler's Cove. I have a concern about the concept of 12% of the voters having to petition through the initiative process. Right now, state law says that 11% of us could go out and try to embark on charter government from the citizens level. So 12% seems to me to be very onerous, as even does the 6%, or the 8% rather, that's been referred to. In Brevard, it's only 5%. And in the supplemental that was added to your document from Ms. Carol Palmer, it seems to me very logical that not 6 months to collect the signatures, but 1 year to collect the signatures, and in there it's 6% of the electors qualified. To me, if we're, I think that's much more palatable to the average citizen, and continues the thought that charter government does bring power to the people. Also, to have to ask that 60% of the voters approve the charter? I guess that's what you mean.
No.
Oh, you want 50% for the 51% for the approval of the charter, but 60% for any add-on from a charter changes. I think that's being a little bit hypocritical in a sense, in that if we're saying only 51% have to approve this major change, then why do we have to go to 60% if a duly constituted charter review board or an initiative from the citizens comes forward and says this is what we think should be changed in future years? I would like to see it just remain 50% plus. I also urge you again that we not get lost in the details and turn it into a miasma of unknowns here, because the original term charter light, I think, is what we all seek. I think we've made it clear, I think most of the people by their 71% vote understood what it was we were voting for, and we don't want to change hardly anything at all except those protective provisions that we asked for. And I am a little dismayed reading remarks in the paper and other places that there is such resentment from officials in Fellsmere, for instance, that we, the citizens, through charter government, would like to control that part of our destiny. It's almost, I won't say they want another Palm Bay or another Port St. Lucie. I don't think any sane person living in this county today would want that. But history shows that that's what we would have if we can't use the Seminole County provision and protect annex lands under future charter government. Thank you very much.
So let me ask you a question, Mr. Williams. So you're saying that if we want 60%, then you think the charter should pass by 60%?
No, sir, the opposite. I think the amendments...
I know what you're saying. You said it was hypocritical. Well, if you did one or the other, it wouldn't be hypocritical. It'd be consistent.
Well, yes, but you're going consistently in the wrong direction as far as the intent of the founding fathers is concerned. Thank you.
Mr. Chairman?
Yes.
The issue of parcel of land has come up. There is a definition in the Growth Management Act. A parcel of land means any quantity of land capable of being described with such definiteness that its locations and boundaries may be established, which is designated by its owner or developer as the land to be used or developed as a unit, or which has been used or developed as a unit. So it would be up to the owner whether to designate all his, holdings that are contiguous as a unit or not.
Okay. Mayor?
Hi, Richard Dunlop, 426 Indies Drive, Orchid. I also am the mayor of the town of Orchid. As some of you know, I think charter government's not the way for us to go, because I've seen what has happened in the other 19 counties. I know you have, for example, the head of Habitat here. In Pinellas County, do you know that in Pinellas County, the county is trying to regulate all charitable solicitations? I think you have to be very careful what you put in to a charter government. if we're going to have a charter government in this county, I think you need to have dual referendums, which means the county votes and each of the municipality votes whenever you are going to change or affect an ordinance in any of the towns. I don't think we should have a charter government that does not have dual referendum. Therefore, members in one area cannot force their desires down the throats of other municipalities. Wesley, if you want something to consider, 43rd Avenue is not the only thing to consider. You ought to consider Indian River Boulevard, what could happen there. Commissioner Bowden has trouble getting to the county building. Can you see that road from the Barber Bridge going straight through Vero Beach Country Club?
And by
right
referendum,
here?
that would pass.
By a referendum, that would pass. So you have to be very careful before you take this step.
And I dare raise the question, of course, whenever I see Mr. Williams come up, I dare say anything about any fire department or fire station or something, initiative to, and again, though, it was a very good point Mr. Barone made, not to get bogged down.
That's prohibited. You couldn't do that, unfortunately.
Why? And that's because it's a capital project?
No, fire stations, firefighter salaries.
We need to, unfortunately for the recording here, TV and the public, you're going to have to be at the podium.
That's okay.
Yeah,
I just think you need to take a careful look at all the pages and pages of activity that has gone on in the other 19 counties. And it's only 19 out of 67 that have taken charter government. It may be 80% of the population, but they're moving very quickly into areas. And I understand you say charter light, but most of these started out as charter light. They're not light anymore.
So, Mayor, let me ask you, if you were, if for instance, if this was in here, that you have a dual ordinance, that
Dual referendum.
dual referendum for an ordinance that would be changed to take precedent over with the city, the current boundaries, would you be happy with that now?
No,
With
I'd
the
be
charter?
happy with 171.2.
Well, if we
I know
can-
you weren't there Friday, but I
No.
really think that solves the problem that you have here in the county, and I think that's the appropriate way to go at this time.
Okay.
Does that answer the question?
Yeah, I'm sorry. did you-
We need to take a break or
Oh, yeah, I'm with that. No, I think it does. I'm just saying that, I know where I'm coming from on this charter, and it's not to interfere with the cities or the city's authority. It is to, as you sat here and as we look at the cities and we look at the unincorporated area of the county, the cities have an opportunity to gobble up the unincorporated areas of the county. And in order for the county to protect the unincorporated areas from being taken over by cities and then the densities or others being changed, the only thing where I'm coming from on this, and it's been clear for 2 years, is to protect the land use that currently exists. It's not to go in and ask the cities or try to take authority away from the cities. And in fact, as much as I'm opposed to heights, buildings, or higher densities, if the current cities wanted to do something in that area, I can live with that. I'm trying to look forward from this point and not go backwards and say, no, we're not going to allow you to go to 20 units per acre and put condominiums up 10 stories. If you're in the city now and that's current property and that's what you want to do, I may not like it, but I'm not trying to stop what authority the cities have at this point in time. I just simply, and that's the other reason I'd like to have this, as one commissioner, difficult to change, because I don't want to see down the road where other future commissioners want to come in and try to take the cities over. Not interested in that. But anyway, that's where I'm at this point. And so, I don't know that we're that far away, but it's just how we're going to get there.
Right.
So,
But I'm also looking 5-10 years down the road. The 5 of you will not be sitting up there, and I don't know who's going to be sitting up there. And I don't want to open Pandora's box. And I think Wesley referred to Pandora's box on 43rd. I mean, Pandora's box can be all the unknowns we can't even dream of, everyone here in this room.
We're looking at basically from charter light to charter might, I guess. What could it become?
well, I don't know. I think also that whatever concerns we have about what the electorate may do, depending on who's setting up here and depending on elected officials in general, or maybe not in general, but perception-wise anyway, it's a whole lot easier to get the 3 people to change something than it is the electorate. So if it's something bad for the county and you want to try and get it through 3 commissioners, or do you want to go to the electorate? I'd go to the electorate.
But if we make a very tight 171.2, and I know today's not 171.2, and it's signed by all 6 entities, the 5 towns and the county, that's going to take a lot of people to change that. And if we make it for a long-term period and make it onerous for anybody to get out of it.
And I'd like to see that happen, and we've got several months to try and make that happen.
Well, we're working on it.
Yeah, I know.
Thank you,
Appreciate
Mayor.
it. Thank you, Mayor. We need to take a 10-minute break to allow for captioning. We'll be back at 9:47.
Last recap.
Call the meeting back to order.
Can't wait till somebody else gets a chance to do that.
And
Bill doesn't
Mayor
look at
Cadden,
those books. Don't worry about it.
would you like to? Mayor, would you like to come up?
Good morning, Commissioners.
Good morning.
Appreciate being here. A couple of comments about the charter charter draft that we've seen.
Please, Mayor.
Oh, I'm sorry.
Mayor.
Tom Cadden, Mayor of Indian River Shores.
Thank you, sir.
Rather than generalize on several other subjects, I just want to address the draft. We've seen it. 7.4, repeal. That was one of the things that we were going to ask you to put in, so thank you for having it there to begin with.
Okay.
Dual referendum, I understand, or dual vote when it comes to moving people and assets requires votes of both the municipality and the county. I think it's important that that be broadened to include other charter amendments. Charter amendments that are going to affect municipalities should be dual voted. And I have language to that effect. I haven't shown it to our attorney yet, so I assume we'll have more meetings like this, and I'll be happy to bring you the language or send it to you before the next meeting.
Yes.
Mayor,
Yeah,
if I could, give you an example of what you're talking about on the dual vote. For example, I don't know, something that you want, let's just take, for example, something that you want to do in Indian River Shores violates, but see, I don't see how that would affect.
No, this has to do with future amendments
To the land use.
to anything.
Anything in the charter.
Yeah, Wesley, once you open Charter Light, it doesn't say light long. It just simply doesn't. That's proven. That's a proven fact with everybody else with charter counties. So what I'm trying to do is protect our town, which is a very small town with very few voters, against big amendments that could change the conditions that we live in Indian River Shores. Now, can I give you a definition of one of those today? No, because I can't see into the future.
I understand.
But what I want to do is if it specifically affects
your town
or would impugn this town or any of the other municipalities, it's not just protection for Indian River Shores, but it would be protection for the other municipalities.
Would you want the veto power or
No, it's a dual referendum. If it passed in Indian River Shores, it passed.
Okay.
It's still a vote.
And if it didn't, though?
If in other words, if the county decided to do it and the town wouldn't do it, then it couldn't be amended.
Let me give an example, just to make sure I understand where you're going. I'll take something hypothetical. Let's suppose that Indian River Shores wanted to take a section of their beach and wanted to, of course, we're not talking about heights, but the way we're looking at this now, I can't think of any way that it would, but let's say in the future that somebody wanted to take a portion of the beach within Indian River Shores and put up 10-story condominiums. I realize that.
No, I think one.
But I'm looking for a ridiculous example to make the point here and to make sure it's understood. So let's say that that's the case, and let's say the city of Indian River Shores let's say the county wanted to do that through the charter. Somebody got a charter amendment on there. You're saying that if it passed countywide and didn't pass in the city, then it wouldn't work, or vice versa.
Yeah, just reverse that, Gary. Suppose the county, and I hope it's unlikely, but suppose the county decided they would allow a 20-story hotel on the beach.
Right.
Let's take and then they said, well, the ideal place to put a Ritz-Carlton is in Indian River Shores.
Let's go to something a lot more less abstract. Let's go to the sand pumping issue. Let's suppose the county decided through referendum that they didn't want to pump sand.
Well, if for instance, through a referendum, if the county, and if we had dual,
right,
both would have to agree to it. If one didn't agree, then it would kill it. And what I was saying, that the county, let's say the county wanted to put a Carlton over there, and it went to charter. And at this point, it probably wouldn't. But let's assume that it could go to a charter question. It'd have to be approved by both.
Yes.
And I'm talking about. Currency. If the city, let's say that the city of, under the charters is proposed now, let's say that the city of Indian River Shores wanted to put a Ritz-Carlton there, the county would have no authority to stop it. And that's fine with me too. I think the cities within their city limits should have their own jurisdiction. I may not agree with everything the city does personally.
Expanding the urban service boundary and everything.
No, they can expand. No, they can expand the urban service boundary. But they can't change the land use without voter approval. They can't go from 1 unit per 10 acres to 6 units per acre or 10 units per acre.
Let me ask you this too. Indian River Shores, commercial property. Say a new group of people came in and bought some parcels of land, put it together, and parcels of land. Made one parcel, and they're going to change the flavor of Indian River Shores by going through the charter thing. So that could happen too, couldn't it?
Yes.
So
my concern is
not only the county, but the cities as new people come into cities.
I know the public position of the commission sitting in front of me now. I don't know what it's going to be.
Right.
5 years from now, 7 years from now. So I want to make sure that the municipalities are protected with the dual vote.
Mr. Chairman, and Mayor Cadden, I agree 100% with you that anything we can do to give the municipalities as much protection and preserve your individual home rule, I am all in favor of. I just have one question, though, Kurt. We already have in there that I think there's some wording that municipal ordinances will prevail in case of a conflict with county ordinances, except for the area outside the rural land. So we have that protection in there, and then could we say if there's any challenge or change to that portion of the charter would require a dual referendum? Would that be more or less protection for them? Or
let me sort of summarize what I think so we're all understanding what the idea is. To go back to square one, to transfer a service or a power, police department, fire department, constitutionally required by not only a dual vote, but, oh, by the way, actions of the city commission too, to transfer that. It occurs, it's counted once, one election, counted countywide, and within the city from which the service is to be transferred. Other matters, such as regulatory powers, it's very common in environmental protection, since the actions of one area affects the people next door, the people next door, the people in the unincorporated area. Common where the voters have adopted that by a single county-wide vote. Now, what the mayor is asking is that for regulatory powers, that in the future future amendments to the charter could only be made effective, that future amendments that transfer regulatory powers to the Board of County Commissioners may only be effective by the vote of the public if it's adopted in a dual vote fashion. It is approved countywide and approved in the city in which the policy is to be effective. I'm not sure you can do that. I don't know. It's a legal question, and I mean this sincerely. In the Seminole County case, it was quite clear in terms of when a dual vote is required. And I'm not a lawyer, but I think it raises a doubt as to the validity of dual vote policies as relates to regulatory matters. It's something that we need an opinion on.
And that's what I said. Gary, I've had some language drawn. I want to go over it with an attorney. I'm not an attorney. Pinellas County has it in their charter.
Well, that's also been the subject of some litigation.
And I read their charter, right, and I don't understand a word of what it says.
It's a poorly written charter.
Well, Mr. Chairman, I know we can't vote, but if you're looking for a consensus, my support would be to give the municipalities whatever additional authority or dual referendums where we can to make sure their home rule powers are protected.
So marrying that with what was said earlier, we might have a threshold of a 60% vote to approve an amendment, plus for it to be effective inside city limits, it be approved by the voters of the city too.
I am in favor of the 60%.
Thank you.
Okay.
Thank you. Mayor, after you check that out, I'd like you to copy of it, and we can forward it to Kurt and all the commissioners and anybody else that wants to be a public document. But that's something that I would agree with what you're trying to accomplish. I would agree with that.
Okay. Well, next 3 or 4 days, good.
Thank you.
Thank you.
Thank you, Mayor.
B.
Good morning, Commissioners. My name is B. Gardner. I wanted to make a point before I got into some of the details. I've somewhat looked around the room, and at one time there was probably close to 100 people in this room. My guess is there's closer to 75 people in the room. And for such a major, important event as what we're going through today, I don't consider that the voice of the people on going over this charter. I believe this is, as always, the people that are the most affected and the most interested are the ones that are here. And to think that there were a couple things that transpired over the last few months that I wanted to make a point about. My first point was that we were under the impression, or at least I was at the beginning stages of considering charter, that there was going to be a charter commission formed, and it would probably be a series of workshops after the charter was written, and it would be written by the people that were on this commission. But the main point about what this whole process was told to me, that either way we looked at it, there would be a vote in the November 8th election on the charter, approximately, because by the time you form a commission and it takes 18 months to put the charter together, there's a lot of input going on during that period, and that would take approximately 19 months from today. In lieu of this, the commission took it upon themselves, and I can understand why this was done. They went to write the charter by ordinance, which is where we're at today. The thing that bothers me, and this is the point I'm trying to make, instead of going to a vote to the public on this where everybody, whether they were for or against it, that has nothing to do with what I'm saying. There was going to be a long period of time, about 18 months and 19 months, before the public was even going to have to vote on this through a referendum. And it looks to me like right now, today, we have 5 months. If this whole thing is being put together and there's going to be a special election in, let's say, September for the people to vote on this charter, I call that 5 months.
Is that the schedule?
Is that the schedule?
There is no schedule at this point.
Well, that's what we've been told.
By who?
Who?
I believe we heard that at the last meeting that was held at the city of Vero Beach when we were talking about the process. But irregardless of that, I would feel that especially since I've been here for 2 hours and we've only heard about 5 people from the public speak, and most of those are people that have a real interest in this, I'm very concerned about the speediness of what's going on right now. There doesn't seem to be time to look into 171.2 because I've heard, again, at the last meeting, I heard that though this process is being pressed forward, we're still going to have time to consider the 171.2. There's already been a meeting on that. And all of these things take time, and they seem to be that we're being speeded up into this decision-making process without a heck of a lot of input from the public. And as I was reading through this charter, now that's the point I'm trying to make, and whether I'm right or wrong, I'm not going to say I am, but it just seems to me that the public 5 or 6 months from now is going to go to a special election and vote on whether they want to be a charter government or not. I just feel that's a little bit fast. I think there's a lot of issues that we've heard today that even need worked over. And as I was going through this process...
Speed's not one of the things government's often accused of. So.
But in this issue, I seem to feel that it is. I mean, I could be wrong, and I hope I am wrong. If I could get some assurance right now that we would not even vote on this charter until 2008 November, I might feel a little more comfortable with the process. That's my feeling.
You know, and I you know, what you're saying is palatable, I guess, to a lot of people. But, you know, the bottom line is, and I know, and I think everybody that's ever ran for office, you know, most elections are decided in the last 2 or 3 weeks, whether it's a 2-year election or whether it's, but the decision is we got 5 people in the sheriff's race right now and nobody even knows what's going on. They're going to talk to them. But I'll tell you what, most of the decisions, other than their core support, is going to make up their mind in the last 2 to 3 weeks of the campaign. So whether it's 5 months out, 8 months out, a year out, 2 years out, still going to come down to the last 2 or 3 weeks of the campaign for people to make that deciding factor, from my opinion. So I don't see this as being speedy, and I don't think it'll be in 5 months. I'd like to see it happen sometime this year, quite frankly. But I don't know, and I'm one vote, and it depends on what the commission does. So no schedule's been, in fact, we haven't even scheduled the rest of the workshops, which we're hopefully going to get into at this meeting and schedule. I would like at least a minimum of 3 more workshops. 1 in the North County, 1 on the beach side, and then 1 back here at the commission office. And perhaps we could have 2 in the North County, 1 in Sebastian, 1 in Fellsmere, 1 over on the beach, and 1 back here at the, but those are things, and that's what we're here for, is to get input, get public input, get public interest, and move forward.
But that brings me to my second part of my point. How many registered voters do we have in Indian River County? Is it 80,000?
Used to be.
Right. Somewhere close to 80,000 people are registered to vote in Indian River County, and you have about 50 people in here who really care. I mean, that makes it very difficult for me to understand that the public has so little input in something like this on such an important matter. And granted, you think that this is an educational process for the public, but it's an educational process for the people that care. And then you're going to put the people that only care when there's a situation where it's a NIMBY, you know, not in my backyard like the 43rd Avenue. So I'm not opposed to what you're doing. I understand what you're doing, but I think what's happening is the process is moving faster than I would like to see it happen. Normally, you're right, Gary. Government moves so slow that it can drive you crazy, but this seems to be a time when it's moving a little faster. The train has left. The charter's already been somewhat written.
Well, and what we need to do is we've made your point on the election. Do you have comments on the charter specifically so we can have other people talk?
Yes, I do. Yes, I do.
Okay.
Okay. Number one, and I read this charter over the weekend, and the first thing that affected me highly was the last 2 pages, which was the language part. And I had underlined exactly what Wesley Davis had brought up on what is a parcel. So I think that really needs to be clarified in a lot of ways, and it'll affect a lot of things. The other thing that I question, and this is as an overall question, we're dealing with a major issue here that's dealing with a comp plan. Am I correct?
Yeah.
Sort of.
Yeah, you're right.
I mean, we're talking about an urban service line, and we're talking about densities and heights and things like that, that seem to be the reason why this is all going to take place. So my question to you is, at what point during this process are we going to do a whole review of our comp plan so that if the charter takes effect, are we sure we're on the same page on the charter, on the comp plan that we want to be? So I'm feeling like we're dealing with a document that's, or the comp plan, which is 15 years old and hasn't done much work.
I understand. If I could, I think she brings up a good point. At what point do we go ahead and establish the urban or the rural boundary, rural areas? We need to have that in place before we start to put it to
That's the point.
That is in place with our current comp plan. And the comp plan's reviewed twice a year. And every, 5 years, it's completely reviewed. Is that correct, Bob? So, the comp plan has been sitting there and drawing dust for the last 15 years. So, at any rate, but if this was adopted, the current comp plan would move into the charter. And that's something that we work with almost on a weekly basis.
Well, all I'm saying is, I hope that this commission thinks long and hard before you hamstring yourselves, because we vote on you to make the right decisions, and I'm not sure that this has all been thought out as much as it should be. And I know that's what we're here for.
Right.
And I will sit down and let everybody else come up and discuss this document that we're looking at now. I think there's a lot of things in question.
One last comment, B. This conversation has been going on for the last year and a half at least. And I can't think of any other single issue in this county in the last 2 years that has gotten more print than the annexation question, the charter question, the special act question, 171. We've had meetings with all of the city commissioners. I went around with a special act. It's been voted on at the last November election. So it's taken us 2 years to get where we're at. So to look at another several months to finish it, I don't think is moving fast.
I would like to say something, though. I appreciate what you said, because I feel that too.
Thank you very much.
I do think that I would like to wait to the very last minute to see that the municipalities have an opportunity at every turn to come to their agreements together before we would ever really consider going forward with it.
And I think really what makes it seem so fast is we just had a meeting last week, but that meeting last week was not about the charter, it was about the
interlocal.
Exactly. And the meeting prior to that was about the charter, but it was just an introduction to it, and the meetings before that were about the special act of the legislature.
Correct. This is the first one.
I understand, but and I think really the issue is moving fast. But the issue is a candle being burnt on three ends, for the lack of a better term, from the special act, from the interlocal agreement, and from the charter. And that does give the tendency to make it feel like we're moving at lightning speed. It's just more than one direction at the same time.
And to make a long story short, I'm not naive about how governments work. And if the interlocal agreement could be reached, that would probably be to everybody's best advantage. But because of the reason why we're writing or considering a charter in the first place, having to do with annexation of lands and who's got control over those lands up in the Felsman area, I'm not sure Felsman would ever sign an interlocal agreement to begin with. So all things considered, I see where you're coming from, but I really think there's an awful lot of, pardon me for repeating myself, a lot of unintended consequences could happen to you folks matters not to me either way. I mean, I'm not sitting up there making decisions. But I think that there really has to be looked into this in a much more complex manner. Anyways, go on with your meeting. I think it's very informative for all of us, and I appreciate you listening to me. Bye.
Thank you, V. Yes, sir.
Commissioners, my name is Frank Wagle. I reside at 8060 142nd Street, Ursuline Heights, unincorporated, Indian River County. I come here to urge you to adopt single-member districts in the charter. Okay, this can also be done under our present organization. The reason for this is fairly simple. I'm one of the 20% of the population that has the privilege to live in District 1. Okay, we have a commissioner that is very responsive to us. Okay, everyone loves him. Okay, come next election, he can get every vote in the district. Under our present system, he can lose the election because everyone from the other districts can vote against him. Yet he is supposed to be representing my district, and I resent that other people that don't live in the district can get rid of them.
Now, what did that cost you, Wesley?
I don't know, but I'm humbled by those remarks. Thank you very much, Frank.
We don't believe that, Wesley.
Now we can turn it around also, and that Wesley can get us quite upset once in a while, and he can get 0 votes in the district.
That's true.
And still get elected. I really think this is not responsive to the needs of the people that are in the districts. Okay, from the Commission's standpoint, I think it would simplify the elections. Okay, you wouldn't have to run countywide anymore. You just run within your district. Okay, and you would be more responsive to the people within the district. I really would urge that. Another thing is in areas where we have minority enclaves, okay, with a countywide election, the power of those enclaves is diminished by quite a bit. And I'd really urge you to consider this single election, single member district situation, either in the charter or later on if that doesn't pass.
Anybody want to comment on that? I think that's an important issue.
I would disagree with you a little bit.
I would too.
On exactly which part?
We don't
About the
like
District 1 commissioner? Or
not on you.
The performance of that particular commissioner.
This county is not that large yet, and I have many people who call me, not in my district, to help and to do things. And I think we sit up here as a collegial board and are most willing to do anything for anyone, not just in your district. I never looked at it really as just in my district or I think we're statesmen, and we try very hard. And I wouldn't go into Wesley's district if I knew he was working on something, but if he wasn't working on something and somebody called me, I certainly would help.
Yeah,
as
I appreciate
assume you would do in any other district. So
I appreciate that thought.
we're not territorial.
And this would not stop a thing like that.
Right.
It's just, I'm voting for him, he's in my district.
But we're all commissioners.
Why should I vote for you? I don't even know what's happening in your district.
Well,
to follow up, and I agree with what Commissioner Bowden said, I also think that the problem I have, and this has come up in the past, even when I was on the commission before, the problem I have with single districts is that we should be representing the county as a whole. And if you run from a single district, you can get elected based on some very narrow opinions that may not be a countywide, for instance, maybe in Fellsmere and North County, Wesley could run on no sand pumping. where maybe Commissioner Bowden lives on the beach, that would be her issue back and forth, and you only get that district in there. I think the whole county, because we represent the whole county, I think the whole county on a vote on all of us as a whole in a general election, and look at us as a whole and not just where we are to try to appease our special district. And then I look at the United States, or even the state of Florida, and with individual districts. And you know, something seems to get lost for the benefit of the whole state, and something seems to get lost for the benefit of our whole country based on where they're from and what the attitude is from that district. And I think a lot of times they're looking at a very narrow perspective about what they want, which may be good or bad for the country, rather than looking at the country as a whole or the state as a whole.
Okay, you make a good point there, and I would suggest this to you, to try to get the Florida law changed and get rid of districts if you feel that way. There's no need for them.
I found the legislature not willing to change things I'd like.
Thank you. Thank you,
Sal?
Wow. Don't hold me up this time.
Good morning. Sal Neglia from Sebastian. I just wanted to, if you can clarify the dual vote, dual referendum for me, just for a moment. You were looking for some examples before. There's a possibility up in Sebastian to annex a piece of commercial property, bring it into the city, and if we wanted to go to a referendum, to have the people let us know if they wanted us to buy this piece or not, that would be a dual vote, dual referendum, the city and the county?
No, I think, Sal, what you're looking at annexing is already in the urban service area.
Yeah.
Wouldn't change. If you were going to annex something outside the urban service area,
okay,
and by the fact that you annexed it, it'd come into the urban service area. But what I'm in favor of, and I'm one commissioner, you couldn't change the land use of that without voter approval, unless there were less than 5 parcels as mentioned in here. But what you're talking about annexing is already in the urban service area. It's already zoned commercial, and even if it wasn't zoned commercial, you could annex it in the way this is proposed anyway.
With the one vote?
Yes.
From the city?
Without a vote, without a referendum.
Yeah,
without any vote.
And so if they had,
you as a council,
if they had,
well, I understand. Excuse me, I'm sorry. No. I understand it's up to the council, but we've had some of these issues where we want to go for a referendum and whatnot. Right. I've just used that as one example because we were looking at some before. I just want to make that clarify when I go back to the city and explain what's going on.
Yeah, that wouldn't be effective.
Mr. Chairman, if I could, just so I can clarify it in my mind then. So if the city of Sebastian wanted to annex a piece of property that was inside the urban service area but zoned agriculture that may be L1, and these are real scenarios that I'm laying out, which is low density, 1 unit per acre in our comp plan, they could annex that and make it commercial without it going to referendum if it were.
That's my understanding as I read this.
And it's less than 5 parcels.
Right, okay.
And that's my understanding. Kurt, if I'm wrong, but that's my understanding, and I would support
this. This does not affect
rural area.
Annexation process, separate annexation process from the comp plan policy. This does not affect annexation policies at all.
At all.
And if it's an area where there's voters, you, I believe, would be required to abide by the annexation dual vote. If it's a voluntary annexation where it's mostly commercial property, you would get 50% of the property owners to agree to come into the city. But this doesn't affect that one way or another. Now, changing once the area is into the city, I think that the policies of the comp plan as existed prior to assuming this was adopted, prior to the annexation would prevail.
Well, that goes against what I heard Commissioner Wheeler say he understood.
And it goes against what I understand. I think we were talking.
And I'll give you a real example.
I'm sorry, I thought this was outside.
No, this is in the urban service area.
No, this basically a change of intensity of land inside the urban service area. It would or would not be affected by this.
Would not be affected by this.
Okay.
Can I ask you too, did I understand that you said that as we have it drafted, to change a comp plan, it would have to be voter referendum for the county?
Well, there are different options here. It depends upon what you
But in the municipality, you wouldn't have to have a voter referendum to change the comp
This would
plan.
not affect the comp plan in the municipality.
Unless it was annexed property.
Unless it was annexed
Outside
out of
the urban
the,
service.
outside of the
Thank
urban
you.
service.
Yes, annexed property outside the urban.
Well, I have a concern about having a referendum for the comp plan change.
Right. To change the plan in the, outside the urban service boundary could be by the simple majority vote of the county commission, majority plus one, or by referendum of the electorate.
Well, we really have to think about that to see the consequences, unintentional of all that.
Okay. Mr. Bass?
Thank you. I'm Jeff Bass. I live at 1281 Indian Mountain Trail, Vero Beach. I just find this whole thing so contradictory. This started 2 years ago as a result of people concerned about what was happening inside the urban services area, yet we're attacking outside the urban services area. Doesn't make any sense to me. This is growth management by referendum. This isn't growth management by planning. I think the Growth Management Act states that you have to have planning, data, tons of analysis to change a comp plan. None of that's involved in a referendum style of government. It makes sense to me that if you want something, you plan for it. You set a goal, you work toward it. Yet you're not working with the people that own the land. The landowners have the opportunity, and you have the opportunity to work with the landowners. Tried that for a whole year. No planning was done. All the time, every time we tried to plan, we got circumvented. I think there's a lot of room out there to do a lot of planning if we didn't have to fight things like this all the time. Another contradiction, I believe. The way to get things is through incentives, not regulations. If we're given the proper incentives and we have the proper plans and the proper goals, I think we can achieve what we all want here. But by doing it but try to regulate everything is the wrong way, in my opinion. Thank you.
Thank you. Anyone else in the center section like to be heard? No one? On the left? Mr. Higgs?
Good morning, Commissioners. Thank you for giving me the opportunity of speaking. My name is John Higgs. I live at 45 Wax Myrtle Way. First of all, I think all of us should thank Mr. Spitzer for his clear and quite neutral presentation of his ideas for a charter. I think this has been a good meeting. Anyone who has wanted to speak has been able to speak. And of course, as we all know, there are many people watching this on television. So this will be given lots of people in the county will have lots of opportunity to talk about what's being discussed today and to give input to their elected officials. What brings us here today is, of course, our concern about uncontrolled growth in our county. Many of us believe that if something isn't done to restrict the uncontrolled growth in our county, that we will lose our present way of life here. Once the rooftops go up, you can't take them away, of course. And I believe, and I know many other people do, that those of us who live in, all of us who live in the county, have an interest in what happens in all parts of the county, because we live here. If a community annexes land from my county, it affects me as well as the people who live in the annexed property and the people who are doing the annexing. That's why we're here. Now, there are two ways to address what I consider the problem. The first is by an interlocal agreement. I have said that if a proper interlocal agreement is made, having a long term, that in my view and in the view of the IRNA, the need for charter government would be diminished and probably expire. That process has been started. We will see if it works. And meanwhile, we have the other option to protect our way of life. And we must move forward, not quickly, but we must move forward, because once the rooftops go up, and once the western part of our county look like the western part of Palm Beach County, you can't go back, and we've lost it forever. I'd like to make a couple comments about the discussion on dual referendum. As I understand it, seems like a good idea. Once we get a charter in place that has proper restrictions on the use of land, then changing the charter to affect the use of the land would seem to be an appropriate subject for dual referendum. There has been a lot of discussion about dual referendum, and I think that many people mean different things, but I think if we start with the basic premise that once we have what we want in place, it can only be changed as it affects a municipality with the approval of the voters of that municipality, is a good idea. And I think that Mayor Cadden and Mayor Dunlap have brought a valuable thing to our meeting. I would like to spend a couple minutes, but not going into drafting details, to talk about protection for our constitutional officers. I think the draft, which of course is a plain vanilla draft, and this is no criticism of the draft itself, does not give appropriate protection for our constitutional officers. I think it should be clear, as it is now actually in the draft, that they are not subject to recall. I also think that section 5.1, 6.13, 7.31, 7.32 should all be changed to make it clear that no amendments to any of those sections can affect the powers, the duties, and the functions of the constitutional officers. I think that's very important, because the way the plain vanilla draft is drawn, a simple amendment to that could change the duties, powers, and functions of those people, and I don't think that's the intent of anyone. An amendment that could change any of those things should have a large majority. I would suggest 75%. Because we do not want those people to feel vulnerable that the charter, once in place, can be changed to affect their powers, duties, or functions.
You just want it to be the county commission that can be recalled.
I got a question
Yes.
on that.
Yes.
If the issue of recall is, I heard you say the issue of recall is non-negotiable, or in this.
Not for the county. It's not negotiable for the county commission.
Okay.
You will be subject to recall as provided in state law. You can't, the charter can be silent, but you're still going to be subject to recall as is provided in state law.
But clearly there is wiggle room for the constitutionals, other constitutionals, because we're constitutionals also.
You could. Other charters have provided that the constitutional officers are subject to recall. This charter does not, and I think for it to apply to them, you'd have to affirmatively say that it is applicable to them, and it doesn't say that. If you want to have some sort of language in there that clarifies it even further, that it doesn't apply to them, you can do that.
I think, too, it's the salary. I've seen other counties that, for charter officers, constitutional officers, they change their salary.
And that is one of the sections that I'm not trying to turn this into a lawyer's drafting section, But there are a number of places in the document, and I would be glad to provide the commission or Mr. Spicer with the references in more detail if upon request, where we should make sure they have bulletproof protection from things happening in the future that we promise aren't going to happen today. We want to make sure those promises are firm.
I would agree with which as far as the constitutionals go. I think the constitutionals have a different responsibility than we have as commissioners. The constitutional officers are their position is dictated by law, and therefore they're administrators, and they don't set policy. If somebody disagrees with the constitutional officer, it's going to be over their management style and what they bring to the table as far as management style. Where we are the legislative branch, and we sit here and do various things that directly affect the future of the county. So I think that to recall a legislator is, to have that ability is more important than recalling an administrator, which all 5 of the other constitutionals are. They don't write the law, they don't decide where we're going as a county. We approve their budget and they manage their office.
And just to agree with you, Mr. Chairman, you get arrested and you're going to start an initiative to get rid of the sheriff. If you don't like your assessment, you start an initiative to get rid of the, that's not the way to run a government. And I think that the document presented can be made stronger than it is now very easily. It's not a problem at all, and it's certainly permitted under the law.
Just to be clear, the things that the legislative body can be recalled for are specified in statute, and it's a tough test, as it should be, to meet. And matters of policy are not something that you can be recalled from just as being arrested or assessmenting your home, or would not be something that the constitutionals could be recalled from either.
Well, but that wasn't the point I made. You arrest someone and they start an initiative. It may or may not be valid. The courts might not hold it, but you have a human being that's spending his own money to defend his political life or because someone doesn't like a decision he made. In any event, my point is that I think the constitutionals can and should be protected much better than they are in the plain vanilla document, and that's easy to do. As far as amending the charter, many of the mayors have expressed concern about charter light or plain vanilla charters becoming more onerous in the future. I think those concerns should be addressed, and it can be addressed by making it difficult to amend the charter. Again, this plain vanilla document does not have what I think are in the left-hand side of the page, not the right-hand side of the page. It's not tough enough to, it should be made harder to amend. And again, there are many ways to do that, because the charter can be amended by initiative. I would think 66 2/3 would be enough. It could be amended other ways. We should have it very difficult. And again, the details of that can be worked out later. I would like to quickly address the language, the optional language, and to state why I think it isn't quite what is best, and then give some ideas, or ask Mr. Christopher to give some ideas of what we think would be better. Section 1 states that a comprehensive plan amendment cannot be amended unless it is approved. I think that is too broad and too restrictive. There can be many amendments to the comprehensive plan that are simple adjustments. I think that this commission in the last couple of years has made a few small ones, and there is absolutely no reason to tie your hands or the people who live in the county's hands by having something so restrictive. The 5 parcels is obviously a problem. The problem was not created by Mr. Spitzer, and it's not easily solved by adopting a charter of government. One thing, I think there are two things that would be helpful. First, by having unanimous approval of the county commissions whenever the five-parcel rule would kick in is a good idea, and of course, that is in Section 2 of the proposed amendments. Secondly, I would urge not make the references to 163.3167 quite so specific. Those things could be changed in the future. Those sections could be changed in the future. The legislature obviously is trying to frustrate the efforts that we are here today addressing, and I think it can be drafted in such a way that that would not be a problem. The amendments do not address height restrictions. One thing in Indian River County that I don't believe is controversial is the height restrictions. The county has height restrictions, Fellsmere has height restrictions, Indian River Shores does. I think, and again, height restrictions in one part of our county affects all of us. Now, the height restrictions that exist today throughout the county vary a little bit, but they're basically the same with the exception of a couple small parcels in Fellsmere, which I don't think anyone has any big problems with. I think in the spirit of this charter that all of us who live in the county have an interest in what happens everywhere in the county should be carried through, and these sections should cover height restrictions. Nothing would ruin our county faster than having the high-rises all over the place, and that would not affect just the people who live in the neighborhood. The documents that I have given you, or the page that I gave you, is my idea of what should be contained in the county restrictions. I think that they are good, workable ideas. They make exceptions for anything to do with industrial and manufacturing use, so this will not restrict the economic development of our county. They make exceptions that it does not have anything to do with any municipal projects which are necessary. For example, if a community has to build a waterworks or a sewer plant or something like that, that is really up to that. It doesn't have to go to referendum. Those are my own, all my comments. Thank you for your attention.
Thank you, Mr. Higgs. Any comments, questions? Anyone else like to be heard? Mr. Bailey?
Good morning. Excuse my voice, I've got laryngitis. My name is Ben Bailey, and I live at 941 Sandfly Lane. You know, it appears like this charter amendment is kind of a foregone conclusion, and I haven't found anywhere in the county that it's a mandate of the people. I think if one word sums this up, I think it's unnecessary. The reason is we've had a representative form of government here for many, many decades. You know, our founding fathers here started out doing a good job, and I think the subsequent commissions have done a good job. You know, obviously we've made mistakes in the past. We're all human, but I think we have had conservative, for the most part, commissions. It has worked. I think this thing has got far-reaching effects that, I mean, we're not talking about now. We're talking about 5 years, 10 years, 20 years down the way. I think we're taking the wrong approach on this. Whatever you say, Gary, and I, you know, you and I are old friends, but I have to disagree with you on this. I think this is on the fast track. I think it should not be on the fast track. This is too big a deal. This may be the biggest thing that ever happened in Indian River County. And we all are conservative around here. You know what? I mean, I've lived here all my life, and we've heard people who've lived here 5 years and 10 years, and that's wonderful. And everybody should have a vote and a voice. But, you know, there's a perception question here, and it's pretty widely perceived that there's a small core group that is really pushing this thing. We haven't had a mandate from the county from the citizens of the county of Indian River. Most of these people own homes. They don't own businesses. They don't own property other than their homes. And they're seasonal, and that's fine. I mean, they can say whatever they want to. There's certainly not a law against that. But there are other things to consider. There's the business community. There are citrus people who need to be considered. There's the manufacturing. We haven't heard from those. We have not had a mandate to do anything on that. I don't want any one group controlling this city or this county. We're pretty diverse, and I just think you need to be cognizant of that and not let that happen. I think you're free thinkers for the most part. I don't know two of the commissioners very well, but I know the other three, and you are very intelligent people who make decisions. This has worked for us for a long time, and I would urge you to keep it in this form of government. I don't think the sky is falling by any stretch of the imagination. We have comp plans that are reviewed twice a year, and certainly every 5 years. So I think we as voters and as commission members need to be very careful what we ask for, because if you get it, sometimes it comes back to bite you. These 19 charter amendment counties, there are some real disaster stories in there. I mean, this is not a panacea for any of the problems that we or other counties are having. You've got the opportunity for the intergovernment agreement to work. I think we ought to slow down, look at this thing, and do what's best for all citizens of this county. Thank you.
Thank you, Mr. Bailey. Anyone else like to be heard? Nancy?
Good morning, Commissioners. For the record, my name is Nancy Offit. I represent the Treasure Coast Builders Association. I've lived in Vero Beach for almost 30 years, and I've been monitoring local government for probably 25 years. As Mr. Bailey just mentioned, what we have going now has served us very well. I realize that Mr. Higgs and his group, the IRNA, have won recent elections, and I applaud them for that. They're slick, they're good, their website is very professional, they're well-spoken, and they're very educated. But I suggest that they didn't win they won an election, and now, through their representatives on the commission, and specifically Mr. O'Brien, I know you brought this initiative forward, we're looking at a coup d'etat. We're looking at a change of government, not just an election, not just new faces. And I think that is so presumptuous to think that generations or commissions after you should have their ability and their power of judgment and the vote taken away. And we can say that it's so we're not taking it away from the commissioners or representative government, we're giving it to the people. Well, that Jeffersonian approach is hogwash, because we all know, as Bee pointed out, the room isn't full as it was at the beginning. We know that it's far easier for a small group with a specific agenda to mobilize than it is to energize a disinterested majority. And I think that's what's happened. And it's not a good thing that the majority stays home when there's important issues to be discussed. But these issues are complex beyond a lot of our own understanding, and we're not professionals in the business. I know that even people, members of my own family, if I start talking, or Harry, my husband, if I start talking about this stuff, I see his eyes glaze over. He could care less. And I think that's just a fact of life, that the things that we're interested in, we respond to, and the things that we either don't understand or don't see how they affect us, we ignore. Ballot initiatives, which these would become, require the establishment of PACs, political action committees. Anything that's to be decided on the ballot has to be organized, and the fellow with the the group with the most money, or the glossiest campaign, or the sound bites, or the whatever can move, that's what's going to affect land decisions, land use decisions. And I suggest, it's been spoken before, that these are far too important to be left to politics. That it's very important that land use that determines the future of our county be determined by good planning. Mr. Higgs mentioned, and I hate to attack him, but I think he represents the organization that's behind most of this. He mentioned, when talking about constitutional officers, that you wouldn't want somebody who'd made a bad decision on your tax, or your tax assessor, or if you're arrested, you don't want to go after the person because somebody might start an initiative. Well, I suggest that that's exactly what the IRNA has done. They have started an initiative over growth issues that concern all of us. And the reason that I identified myself, other than for the record from representing the Builders Association, is because I wanted to make it very clear that the builders in this community, the Builders Association, I can't speak for everyone individually, of course, they don't want to push the urban service boundary. They don't want to increase densities. They just want the opportunity that the rest of the community has enjoyed all along, and that's when a good project comes that we can count on our representatives with the input of staff, professional planners, to be able to make decisions that are in the best interest of everyone. So with that said, I don't want to repeat other comments, but please be very careful what we wish for. And thank you.
Thank you. Mr. Christopher.
Mr. Chairman, George Christopher, 945 Painted Bunning Road. I've got to respond to a few things said by my good friend and neighbor, Ben Bailey, and to B. Gardner. But before I do so, let me respond, and not that Nancy's not a good friend, I just don't know Nancy. To a couple of things that she said. Let me start out there. The IRNA didn't win any elections. The majority of the voters won the elections, and you elected representatives won the elections. There's suddenly a myth. The IRNA is being made an issue, or being made the issue. It was just said that the most money wins the election. Mr. O'Brien was outspent $2 to $1, including the money that the IRNA PAC spent, and he prevailed. We're not a group of seasonal people. The majority of the voters are not seasonal people. They're residents. It's not a small group. It's the majority of the voters. This issue of charter government has been before the county for at least 2 years. 71% of the voters said they want a voice in how the land outside the urban service line is to be developed. They're not here today, perhaps because they think you're doing what they want. If they had a trouble with this has been well publicized. It's being televised now. They'll be at future meetings, but I suggest they're not here now because you're doing what they want. The legislation that was going to handle it, I think Mr. Davis said that's dead in the water. So this is the only game, unless, of course, the intergovernment agreement can be brought forward, but that still hasn't seen the light of day. But if it does, so be it. Mr. O'Brien made the charter issue a major campaign matter. He discussed it thoroughly, and he had a major upset in getting elected. I think this shows you the people like the idea of charter government. They're not afraid of it. So I don't think you're moving quickly. I think you're moving on an important matter, and I hope you proceed. Let me mention a couple of small details. The residence of the commission, I hope you'll change that so that the residence is established at the time of qualification. The special meetings, 12-hour notice. Give me a break. There should be a 2 or 3 day notice requirement, and you should stay to the single purpose for which it was called. On ordinances, I think what you have before you is very good. Yes,
George, I'd just like to comment on the 12-hour meeting and 2 or 3 day meeting. A special call meeting can be called for various things. In fact, We had a special call meeting a year and a half ago that I think there was about 30 minutes notice because of something that had to be done. I think it was the emergency matter with a hurricane coming this way or something of that nature. I know that I was at the dentist and was unable to attend the meeting and was marked absent because I had 30 minutes notice. But the majority of the commissioners were. So there are reasons to call an emergency meeting or a special call meeting without waiting 2 or 3 days or even 12 hours. And at any time that's called, 3 commissioners can say, no, we don't want to do it.
Yeah, during Francis and Jean, we called a lot of emergency meetings without the 12-hour notice because of it was a natural disaster and we had to have some decisions.
Well, I would not ever agree with our chairman, but having said that, the lead-in is if practicable.
Yes.
So that gives you your out. Or if emergency, I'm not talking about emergencies, obviously, but this is a small point. The ordinances as proposed, I think, is an excellent way to handle it. Put aside the vote and even the vote going up the way it's been proposed, which is the commission can reverse an ordinance adopted by initiative. In other words, if the voters voted the ordinance, the commission, by a simple majority, can reverse it. And that just seems to me to work just fine. The dual vote for the municipalities makes all the sense in the world, and all you got to do is amend section 1.8 to say that that section alone requires a dual vote. Once you say that, then the municipal ordinance is always controlled. The 5 parcel issue is terribly troublesome. I don't know how you fix that. That's state mandated. It's Tallahassee saying when the people can, when the people are entitled to vote. One way to possibly handle, well, the unanimous course is one way to handle it. The other way to handle it maybe would be think about providing that the any change to the comprehensive plan must involve more than 5 parcels. On the special provisions that are at the end, I'm confused by them. The ones particularly in 3, paragraph 3, if that's intended as an option, okay, but it's contradictory to much of what's in 1 and 2. So I just don't understand what 3 is getting at or why it's there, and it seems to be contradictory to the basic thrust, which is you can only change density or intensity or height by a comprehensive plan change, which goes to the voters. But I think Mr. Spitzer has done a great job. You're doing good work, and keep going. Thank you.
Thank you. Is there anyone else who would like to be heard? Anyone? See if anyone else wants to come up first. B. Is there anyone that hasn't spoken yet that would like to be heard? B.
P. Gardner, I wanted to bring up something that was said several times during this discussion, something that I had repeated. I never said that the charter government was a discussion for the last 2 years. In my opinion, nobody ever heard the word charter government as a means of keeping the urban service line in place. And if I'm wrong on that, I believe that the thing that the people voted on, and I was all for it. 71% of the people voted on holding the line on the urban service line and writing a special act, having our legislators take a special act to the state. But never has the public ever heard that if this can't be done, we're going to put a charter government in place so that we can do it. And that's what I would like to dispute here, because I never said, or I never felt like this charter government thing ever came about to the public until such time that the straw ballot was passed. Gary, you probably would argue with me that...
No,
there's 2 things going on.
Go back, if I had the expertise, look at the last 4 years, maybe even longer, but particularly the last 4 years, and take excerpts from many of the county commission meetings, this has been an evolution in the works, because at every stop, when this commission, prior to me being here, tried to stop or try to get a handle on the growth issue, ask for a moratorium, ask for various things, the people would show up and it would get turned down. It's the same thing when we went through a $200,000+ village, visioning process, and out of that came the village concept. And the fact that all 5 commissioners voted to exclude that from our comp plan, and then when we were lobbied, it was the minds of 4 of them were changed. And so that's only a part of it, but I mean, it's an evolution. I mean, there's been ways, I keep hearing from both sides. First, from my perspective, and I can only speak for me, I think Nancy said that the IRNA was behind this. I got elected, I think, before the IRNA. They were just forming at that time. People on the last commission got elected without the IRNA. And I think but this is the political system, and I certainly understand it if a lot of
I'm not putting any blame on the IRNA. I mean,
No, wait a minute. It's a matter of coming up with a history and how we ended up here. You're trying to pull this out and look at it all by itself. Well, there's been an evolution that has gotten us to this point because we've tried other things and they haven't worked. There hasn't been the cooperation there for it to work. It's been a tug of war back and forth instead of a compromise.
I will agree with you, and I've been with you and thought the same way you thought all along, but I just feel that, for the public's sake, all of a sudden you get the ability to not move the urban service line according to what the public wants by a 71% vote, and the next day you're talking charter government. These are 2 different things to the public. Maybe you understand the evolution, but I don't think the public understands the drastic approach to government, and I believe it is rather drastic compared to what we're used to. And I think that, even though it all blends together and it means the same thing, I don't think that the approach to the public is the same, and I don't think that I don't believe any one organization brought us to this point, because, like you said, Gary, referendums, moratoriums were put into place many times by votes that were never passed. And if that drastic thing never happened, maybe we have to constantly be looking at our politicians and making them understand that what that referendum said to me, the 71% of the vote that said we do not want the urban service line moved, I believe that referendum is for the people to tell you better not ever change your vote on that. But I don't think that they were looking to change the whole form of government to handle that issue.
Well, and they will have an opportunity in the future to make that decision.
Well, we hope so. We hope so. And that's just my feeling, and I just don't like the feeling that everybody's saying that, I'm saying that this is so drastic all of a sudden. I believe it is all of a sudden. I don't believe that this has been a long evolution to the public.
This is simply a process that we're going through. There's 5 commissioners here. I don't know where the other 5 commissioners stand on this. I have a pretty good idea where Peter stands on it because he ran on it. And at some point in time, there will be a decision made here, and if 3 votes move this forward,
I agree.
It'll go to a referendum. If 3 votes don't move it forward,
I agree, but sometimes I think the only time to be heard is the time you're here. Thank you.
Thank you. Ma'am? Yes.
Hi, I'm Sue Joyce from Orchid. I have a question on the subsection 1.81 about the rural boundary, and it doesn't make sense to me. Would the rural boundary map only include the unincorporated areas of Indian River County, or would it also include municipalities?
No, the way this is, I believe we're talking about the urban service line and what's going on outside that urban service line. That's my interpretation of it. If I'm wrong, somebody correct me.
So would that also include municipalities?
No.
No.
Okay, if that's true, then the paragraph D, it says that ordinances to implement this section. If municipal ordinances are in conflict with this section, then the municipal ordinances are superseded.
Where are you again? Which page?
Alternative language,
Oh, okay, the alternative
subsection
one. Okay.
3.
Yeah. Gotcha, okay.
But if the municipalities would not be concerned with any of these changes, then why that language?
You're looking at 3, alternative 3?
Right, and D, paragraph D.
Yeah, and that's something we talked about earlier, that would have to be cleaned up to fall into line with number 1 and number 2, because they're a little contradictory, because these are suggestions.
Okay, I just wanted to be sure I knew what the rural land was. Thank you.
Thank you. Is there anyone else that would like to be heard? Okay, we will, okay.
You make it.
Adrienne Kopp, 43rd Avenue. I'm sure I disappointed everyone that I only spoke for a few minutes since you're so used to having me talk for so long, but I will keep this short. I haven't attended a lot of the meetings for a long, long time until 43rd came up and I became involved. But since then, with the exception of this last year, I've been at a lot of county commission meetings. And when this all started, I didn't even know what a comp plan was. Well, now I know it very well. I've heard and been appraised of the thought of charter government here at the commission for quite a while. I'm not going to be naive and say I don't understand what the developers are concerned about as far as having a charter government. But I read an article, and I don't really believe what I read, but I just need to read one paragraph of it, because I've heard people time after time come up to this podium today and say all we have to do is do good planning. Well, that's a great concept. Yeah, it's a great thought. However, it doesn't always happen. And the first paragraph of this was in the March 2nd paper. It was under the opinion section, and it said, intersection of royal pain. A lack of long-term planning dooms motorists' creativity necessary for State Road 60 and Kings Highway. Tearing out specimen oak trees, destroying conservation easements, and adding enough lanes to make Southern California envious. That's the nightmare that is State Road 60 and 58th Avenue, Kings Highway. I'm not going to go any further, but, you know, you have a child, you plan to raise them well. You are commissioners, you plan to vote the way that is best for everyone. We all try the best we can. And it's a great thought. It doesn't always happen that way. And even though a lot of people don't attend these meetings, and I understand what B's saying, that the people aren't here, it's not your fault they're not here. You advertise. If you can be here, you can. If you have to work, you watch it on TV. But the point is that people are not as naive as you think they are. And they can understand what's going on. And unfortunately, as was brought up earlier, a lot of the people that just have financial interest show up to the meetings. And as Gary had brought up, there was a meeting that there was 5-0 vote, and then the next vote was 4 commissioners changed their mind. It's not these commissioners, because people lobbied them. The people with the money behind them lobbied them. And that's life. The people need to vote on important issues. This is our county. And it's very nice to stand up here and have some people say in generalities that, you know, things should not be changed. It ran great for the last so many years. Well, it did. Things are changing. If it wasn't changing, we wouldn't have KB Homes leaving Florida. We wouldn't have a big complex on 58th Avenue totally abandoned before one house was built and for sale if things weren't changing. And once all the trees are torn down and the land is ravaged, it can't be changed. So the vote needs to be in the hands of the people for the important matters, and the everyday matters needs to be handled by the commission. Thank you.
Thank you. Last call. Anyone? Jason?
Wanda.
Jason Unamaker, City of Fellsmere. Just the last comment, I felt compelled to point out none of those issues were brought about by the City of Fellsmere or even other municipalities. Vero Lake Estates, issues like that were created in the county. Whether it's a charter form or not, those issues exist. I like to think the city has demonstrated itself as to being a willing partner with the county, whether it's advancing school concurrency, negotiating right-of-way. All our annexation agreements, I welcome people's review of them. We're proud of them. I think they're some of the finest that I think in the state. But the issues that have plagued this county the most right now currently are certainly not Fellsmere's creation, and charter government will do nothing to alleviate those issues. Thanks.
Thank you, Jason.
I want to sit here and think about something. One of them is the issue of residency in order to run for office or qualify for office. And as a sitting commissioner, I would have a hard time raising the barrier for somebody to challenge me in the election. If I were sitting in the audience, it would be simple, but it's almost like passing an ordinance of banning political signs now that I'm a sitting commissioner. And the way I look at that is I look at it as, raising an obstacle that I didn't have to have whenever I ran. So I would have some concerns about that part of the language.
Well, and the important thing is if you're elected, you have to move into the district.
And I'm good with that.
Yes.
But that wasn't a little bit of what was tweaked. So as a sitting commissioner, I don't want to raise that barrier for somebody to run against me if they so choose. I enjoy the campaign. God bless them. Come on. But the other one is the ordinance of as far as the majority, and whether it's 60% or whether it's 50%, and Mr. Williams and his comments. I can't say I have an opinion on exactly which one it should be, but I do have an opinion on it should be equal. And by that I mean it almost smacks of arrogance, I think, on our behalf to think of, because it's an idea that we have to craft, that it can go before the voters and 50% plus one win. But if the people have an idea they want to bring before the commission, it should be 60% or a supermajority. And I don't have a problem with one being 60% and the other being 60%, but I think that truthfully it should be the same either way. Well, either a majority for both or a supermajority for both. And I just say that as a humble public servant.
I think kind of as we go through here, if there's some comments that are made, I assume, Kurt, you're going to try to change the draft a little bit as we go through, and then the public hearings, we'll see what we end up with. Is that the way it's going to work?
I will. You might want to see if there are any comments on Article 1 or Article 2. Or,
okay.
I've been listening to the comments from time to time, but for example, on the residency requirements, I've heard two different opinions on that. So
I've made some notes on some things that I like, but I didn't tie them to each article. I just generally, if we can go through, any other comments, Wesley, that you want to?
Not at this point. I think that just as I heard people talking, as things came out, the more I started thinking about those, there were some issues that
I'd like to ask the commission too for direction here, because the way I look at this is a working document that we're trying to massage into what we would like to end up with public input from this commission. So I think as each one of these meetings occur and we change this draft, and at the end, hopefully we'll end up with something that we either approve to go to the ballot or approve not to go to the ballot. Is that okay with you?
Yeah, no, but at the same time, I think whenever something comes back before us, it's going to have some written language in it.
Yes.
And there's no need in writing language in something that a majority of the commission feels strongly about.
Well, we need, whenever we complete this process, we need a minimum of 90 days for the document once we've adopted it to give supervisor elections that. And so we got 90 days with the document for people to look at it and decide whether to vote against it or for it, depending on whether it goes that far. So with that, I think we'll go through each one. I've got some comments and some things that have come out of this meeting and where I stand on some of these. So and I think also if we disagree with certain things, we can kind of do that in consensus to try and figure out where we're going to go with this document. Right. So Peter, do you have any?
I think I gave most of my specific comments earlier. Probably the one that I'd like to really see is for any type of petition-type amendment or ordinance that requires 5 of the districts to meet the minimum for the petition drive to make sure it's widely supported. And
for instance, with 12%, you would need, what would that, 2.5%, 2 3/4% from each district? Or,
no, each district would have to have 12% of the voters within that district.
Right.
Oh, okay, so it would come out to 12% overall by doing that.
12%
Okay.
overall,
Okay.
but 5 of 5 instead of
Would
the.
come out to the.
I understand Commissioner Davis's comment on the majority vote. It does seem a little awkward. I'm not sure how we handle that because we have changed the Florida Constitution to require a 6% vote, so there seems to be a little impetus or common sense to make that the bar, but probably until we implement the charter, we can't require 60%. It just requires a majority vote, so we'll have to kind of work through that as we go forward. I did want to just make a couple comments from what some people said in the audience, particularly related to our comprehensive land use plan that we currently have. We do have a very, very good comprehensive land use plan. It's been in existence since 1990. Every 5 years it undergoes a very comprehensive review. I think we have a very good planning staff that works very hard on our comprehensive land use plan. And Nancy, I agree. I think all of these projects should go through our comprehensive plan. The problem is when a property is annexed, it takes away our entire comprehensive plan. Our plan is then not effective on those lands. By going with this, we keep those lands subject to our comprehensive land use plan that we all agree we think is a good system. So I think that's the one thing people have to keep in mind is that one of the things and probably mainly in my mind, the one thing I wish to accomplish is to make sure that in the future, those lands come under our comprehensive land use plan. And short of the 171 agreement or the binding legislation, this is the only type of system we can put in that will keep those lands under our comprehensive land use plan. So that's kind of how I feel on all that, and I hope the 171 or the special act goes through, and we don't need to take this step. But I do feel it is a path we need to continue down to make sure that we keep those lands under our comprehensive land use plan. So, Mr. Chairman, that's all the comments I have right now.
Mr. Fleischer?
I just have some general comments. I want to thank the viewing audience that is home watching this or watching it later on TiVo. I want to thank everyone here for attending. Your comments were well received. Next time, bring a friend so we have a full audience. I just want to look at what some of the things we heard today. We heard Charter Light, I think Vanilla Charter, Plain Wrapper Charter, Charter Might, Charter Slight. I think these monikers, these prefixes, the suffixes are not helping in any way, and I think that sort of diversionary tactic coupled with aligning with other interests or people that have interest in this, whether it's pro or con, is not going to help this motion any further. Mr. Spitzer, has that been your experience, that we would begin to see a whole different set of language regarding such a move, whether it goes forward or not?
Well, this is the first meeting that you've had, and I mean, my hope at this meeting was to get input. I think it would be helpful to take these changes, incorporate them into a new document, and then go out to the public and get comments from different parts of the county. That process is generally pretty common in the process.
Open dialogue and controversy and argument are very vulnerable tools in such an activity. But now we seem to be focusing in on throwing different terms into what we're looking at or looking forward to or looking against. And I think we really have to focus in on what the county is looking at and what the people want within our county, as opposed to just stabbing at this and making it a more positive or more negative approach. And I'm just asking that as a public appeal, that we just focus in on what we're looking at as opposed to using language to impose our own personal views. Maybe perhaps just go forward with your personal views and not look at other groups that may be looking in a different arena to make our job a little easier or less arduous, and also your job easier when you go to the polls. Thank you.
My comments are, I've got several of them here, and I'm looking at what I'd like to see incorporated into the charter. First is commission districts, and also the elections stay as they are, nonpartisan. I'm sorry, strike that. Partisan.
Thank you.
Yes. I want partisan elections, and I want the commission districts to each run at large, have to live in their district, and also I think that the way it's currently set up is what I'm asking for. Also, you don't have to live in the district to run, but you have to be in the district to serve. Second is I do not want to include constitutional officers. I'd like to see them set aside in every aspect. The other is, well, that's partisan elections. We got that already. The other is I'd like, under the management end of it, the administration end of it, I would like to see department heads not approved, but at least informed, as you mentioned, to the county commission when an administrator is hiring department heads, to have dialogue and conversation at least, and but doesn't have to be approved by the commission.
Right. During the break, I was talking about that with the county attorney, and I believe that you probably must have that language in the charter.
If you adopt the charter by ordinance, the county executive's powers provide for him to appoint department heads, but with the advice and consent of the commission.
Good.
So that means a vote?
I don't like that, but
I
in the long term, I think you're just, but that's my opinion. I don't think that's a good idea as county administrator, and for future county administrators. You've made the daily professional job become very political, and if that's what you want, I think that's what you should do.
So this is right up there with recall then, on simply what we can and cannot. And the reason why I say that, I served as a capacity obviously on the school board, and we approved the positions with the recommendation of the superintendent, and those got at times very political. They got very personal, and I would love to find some way around that if at all possible.
Yeah, let us work on that.
Okay. Next is I like that anything would have to be passed by a 60% majority, and when I hear the inconsistency or hypocrisy, I don't know. I'm not a constitutional scholar, but I don't know what the various constitutions. I know our Constitution, I believe, was approved by a group of people, and it's 66% of the country or the Congress to change the Constitution. And I think that if this is passed, if this goes to the voters, and if it's passed, I'm more concerned about it being used as a tool to change things a lot easier than I would like to see them change. Once we've adopted this, we go through all this process. If someone wants to get the signatures and put it on a ballot, I don't know how many workshops they're going to have, how much input they're going to have from the public, et cetera. And so therefore, I don't have a problem with 50% plus one adopting this, but I'd like to see from one person, I'd like to see 60% of the electorate change amendments in the charter. I'd also like to see 12% of the registered voters to sign petitions to add that to add a change to the charter in order to get it on the ballot. The last comments on the suggested on the back on pages what is it, 20, 25, 26, 27. Section 1 and 2, I'd like to see them combined, and then clean up the language in section 3 that coincides with section 1 and 2. And my position on that would be that I would like to see a unanimous vote by the county commission rather than a supermajority to change the comprehensive plan amendments and so on and so forth as it's laid out in sections 1 and 2. And adopt 7.4. I think that gives a lot of support to the voters that will be looking at this and take some of our strength away or power away as commissioners.
Can I ask a quick question about some of the 12% and the 60% issue? Is it dictated by statute, the issue of recall?
The percentage?
Recall is.
No. Yeah, because I mean, I wouldn't want somebody to get 60% vote to recall a sitting county commissioner. Nor do I really want them to have to get 12%. I mean, that's extremely high to me.
Well, it's a two-step process, and the first, if I recall correctly, the first step is a petition where you have to get 5% of the voters. Then the person to be recalled has an opportunity to respond. That gets merged with the original petition, but then you have to get 15% on the second process.
So that's delineated in the state statute. It's not going to be delineated in our
It can't
charter.
be delineated in the charter.
Okay.
And I'm strictly talking about changing or adding amendments to the charter.
That's all I was clarifying.
Mr. Chairman, the 12% though was concerning amendments to the charter.
Exactly, to amend the charter, change the charter.
And to adopt those, it was 60% of the electorate.
My position, yes.
And I heard another that the 12%, for example, would need to be obtained in each of the 5 commission districts.
I like that too. I think that.
Mr. Chairman, what about the ordinances?
I don't have a problem with that. I'd like to probably look at that more so, but I don't know where we would where this would be applicable for doing an ordinance.
As in, you want an example, or of bringing an ordinance forward and whether it would need them? To me, I think an issue of sand pumping would be something that would come forward. I don't know if that's in our capital projects or not, or exactly how that'd be delineated with, but I mean, the city of Vero Beach did a referendum on that.
Yes.
Okay. And so I guess the question is would that be something that you would need 12% of the population in each district to get the signatures, and then after that have it a majority vote, or would you have a 60%? Or, I mean,
well, that's not part of the charter, so we wouldn't be changing.
It was a part of the charter as far as how we adopt ordinances.
Yeah, but I don't know if that would be a prohibited subject or not.
Okay, then it's an example, and I get the question is what is it going to take for us to change or adopt ordinances that are applicable?
Well, in the current draft, it would require to present the petition to the voters would require 8% of the voters, perhaps in all 5 of the commission districts. It's presented to the county commission discusses, debates, but if it's not adopted, then it goes in front of the voters, and it must be approved by 50% or 60%.
Well, that's the question. No, I mean, as you craft this and bring it back, I think that's Commissioner Wheeler's concern is, do you have it as 50%, do you have it as 60% in order for ordinance to become effective?
The only thing I'm interested in, an ordinance, I'm flexible. I can go however you want to do it, but I think on changing the document once it's adopted, I'd like to see it 12% and 60%. On the ordinance, if it's 8% and whatever, I'm flexible on that. I just think that if this is adopted, that it should be very difficult to change because it's our constitution for the county. And I think that also, I would hope, would get rid of some of the fears from the municipalities that at some future date, the commission is going to come in and add some things and try to take over the cities, which is certainly not my intent, but we don't know what the future holds. So I'd like to make it as difficult as possible to change our document.
Then plus, just to be clear, then measures to amend the charter that are proposed by the county commission, in addition to the 60% threshold, would first have to be punched out of the county commission by a majority plus one vote.
Say that again?
In order to present an amendment to the charter for the consideration of the voters by the Board of County Commissioners, the current draft says that you must adopt that measure by a majority plus one vote of your entire membership. In other words, you have to have 4 affirmative votes to present an amendment for to the voters for their consideration.
And then once we get that point, then what's the percentage of vote if we go Commissioner Wheeler's way?
60%.
Okay.
I have a question and only from a legal standpoint, is that when you say a unanimous vote for the any comp plan change?
Yeah.
Unanimous?
No, I'm talking unanimous vote to change that in the comprehensive plan if fewer than 5 parcels are coming in. In other words, you can't go to the voters with 5 parcels or less, but if the commission has to deal with that, and that's what I'm saying, I'd like to be unanimous. Then the next thing does go countywide, and I can't imagine, as mentioned earlier, that anybody would be opposed to it, and that's the height restrictions. I'd like to see that countywide, if they are to be increased over what currently exists. And that's what would currently exist in each municipality and the county. And that's simply, again, an increase, not a decrease.
And as far as the language that I've heard from some of the mayors, in particular the Mayor Dunlap and Mayor Cadden, did we have any direction or consensus from the board on how?
They're going to research that and look at it, was my understanding, and I think that's reasonable. If we can do it, I'd be in favor of doing it.
I think it's very important to try to accommodate the municipalities that.
I do too. And then last, I guess, but least, we need to figure out when and where we're going to have our future workshops, so we can work through this. Do you want our staff to come back with dates over the next?
Mr. Chairman, what I almost would suggest is also a time frame that we would like to have. I think Ms. Gardner had some issues. Not that I agree or disagree, but I think it's kind of important for everybody to say, okay, this is the time frame we're trying to meet for this reason, and then work backwards and let's schedule our meetings accordingly. And if you know, I don't know, I'm not the one saying I want to do it this fall or in 2008. But I do think that we ought to go ahead and be forthright with the public and say this is the goal, and working backwards from that goal is the meetings and the times. So
I would agree with that. But I think we need to be flexible enough to move that. If we set a time, we'll be able to, if we don't get to the point we want to get, and we need more workshops, or we need more input, or want more input.
Clearly, just a goal, a plan.
That we can move forward, or move that goal further out.
Yeah.
You know, I'd like to see us, let's see, this is Mark.
Mr. Chairman, if I may ask, are you interested in having this as a single item issue in an election, or are you at the same time where, what is your?
I am interested in a single item, a special election with nothing on the ballot but this. I think this is, as somebody pointed out, it's one of the most important things that we're looking at in the county, probably since 1925, because it will be changing our form of government to some degree. And I would like to have just a special election where the people that come and vote pro and con for this will have the opportunity to do that, and it not be cluttered with other questions. And for instance, if you have it, say, in November of 08, that's a presidential year. We have very, very high voter turnout then, And many of those people that are voting for the president and vice president, I don't think are maybe going to be aware of a lot of the other things on the ballot. And I'd like this to be a ballot where everybody that has an interest can get their vote out and go out and vote on this. The ones that are interested enough to vote. B mentioned the amount of people here, but everybody makes a choice. They make a choice to vote, or they make a choice not to vote. And when they make a choice not to vote, they also choose to let somebody else make decisions for them as far as their government's concerned. And I think small turnout elections, which are a terrible thing in the media, I don't think they're so terrible, because I think when you have small voter turnout gets people out that probably are better informed and have more interest in what they're voting on than just going to the polls to vote for a president and then voting for other things while you're there. So I don't think it's a negative to have small voter turnout.
Interesting.
Well, that's one person's opinion.
Well, and I guess, I mean, I haven't even given it much thought as far as the time until B mentioned it this morning. I do understand what you're saying. I don't know. I mean, I'm thinking, my gut reaction says, let's make it as easy for people to vote on this as possible. And if they're coming for a major turnout in a major election, my instinct says that's when we should do this. But I'm not ready to take a position or make much statement on it, because I really haven't given that much thought.
I'll tell you, what I'm looking at, Wesley, is quite frankly, I think that the chances of this passing and passing by a larger majority would be in the general election in a presidential year, just based on what other constitutional amendments and stuff have been passed. I think my position probably weakens where I want to get with charter government. But I'm trying to, in that aspect, I'm trying to be fair. I would like to see us, I could live with a date. I'd like to see us maybe shoot for October for a special election, which would give us 6 months to put this together. And if we were done in time, and I don't think we could be, if the state has a special election, and it was a desire of the commission, we could piggyback on that election too, which would save probably about $75,000 from what Supervisor of Elections told me about what an election costs to run. So, but I don't know that we'll be ready if they do that, and I don't know if they're going to do it, and if they do, I don't know when they're going to do it. But there's probably going to be a special election on this tax cap thing, from what I'm understanding in Tallahassee. Nobody knows what's going to happen, but they know something's going to happen.
I don't know where to go or what to say as far as...
I'll just agree with me then.
No, I definitely know I don't want to go there just yet.
Well, Mr. Chairman, maybe to appease some of the folks that are worried about that, instead of today trying to pick a date, why don't we say not to occur prior to a date, and so at least people know there's going to be a 3 or 4 or 5 month period before anything happens.
Okay. Can we, Will, can we take, I guess, are we taking action on this, or can we do that at a workshop?
No, you can just make comments.
Just make comments, and then this will have to come back on the commission agenda. Okay, I can live with that. I think, as far as I'm concerned, I can say, okay, that this wouldn't occur before October 1st, something of that nature. We'll have to discuss it at a commission meeting when we come up with give everybody time to kick it around, see where they're at.
On that, if I might, Mr. Chairman, on the the question of what the state might do, you're right, we don't know what they may or may not do, but if they want to do something that is effective for this coming fiscal year, it will have to be presented to the voters very soon. And by soon, I mean late summer or so. And that takes an extraordinary vote of both houses of the legislature to do that, more so than just placing a normally timed constitutional amendment on the ballot. So but if that happens, it might be in August or something like that for that to occur.
Yeah. I think if we were ready and the state had a special election, be your decision to make. But but I don't know if we can be ready by then or not. It depends on when we can get our public hearings scheduled, and I definitely think, from my perspective, we need at least a minimum of three more. We need one on the beach, one in the North County, and then one back in here again. And I don't know, whether the turnout's going to dwindle or what, but I'd like to give everybody every opportunity they can to give their input.
Mr. Chairman, in regards to that, my recommendation would be we schedule at least one of those in the evening hours so that people that are working and such would have an opportunity to come, or maybe two of the three in the evening.
I have no problem with that. In fact, probably North County, that would be very good. They seem to get better turnout in the evening than during the day. So, yeah, and I'm flexible on that. So we can go back. We'll put this on next week's agenda, I guess, and discuss it and see if we can iron out the dates. That's everybody's consensus. Okay. Anything else? Any last comments? Matt, thank you, Mr. Spitzer, and we're adjourned.
Thank you.